And we are recording.
All right. Welcome everybody to the Ad Hoc Commission first meeting of 2022. Wishing everybody a happy new year. Hope you all had a great holiday season and looking forward to a fun year of work on this commission. I guess first, Justin, do we need to take roll call?
Yeah, I will
all
take.
Right.
Yeah, I'll take the roll.
Right, let's do that.
Michelle Anderson.
Present.
Karen Bell.
Present.
Ray Buenaventura.
Present.
Shanae Buffington. I see Shanae on there. She's on mute. Hyland Chen. She was going to be late. Ruben Duran. I believe he was going to be late. Shirin Ershardi.
I'm here.
Gary Farwell. Let's see here. Sarah Good.
Present.
Jenna Jones.
Here.
Shalon Joseph.
Here.
Janet King.
Here.
Jerry Larkin. I saw Jerry earlier. Melanie Lawrence.
Here.
Ed Lear.
Present.
Alexia Mayorga. I see Alexia. Judge McGill.
Here.
Steve Moab.
I'm here.
Cynthia Nakao.
Good morning, I'm here.
Morning. Ellen Pansky.
Here.
Eloise Rosenblatt.
Here.
Linda Schneider. I think she was going to join us later. Sean Seleg.
Here.
Brandon Stallings.
Sure.
Judge Wang. I know she had a conference this morning. And Martin Winfield. Okay, we have a quorum.
All right. So moving on to the agenda, item 1 is the chair's welcome. I just wanted to introduce myself. For those of you who don't know me, my name is Brandon Stallings. I'm the vice chair of the Board of Trustees and was appointed as chair of the Ad Hoc Commission by Ruben Duran. So thank you to Mr. Duran for the opportunity to work with this incredible group of people that's been assembled to look at certain issues involving the discipline system. As you well know, last year we accomplished a lot as far as study. A lot of that is due to the hard work of staff at the state bar. And then really just want to thank each and one of you for volunteering to help in this important work. So looking forward to getting the updates from staff, recommendations, as well as potential steps forward here in the new year to continue to study the discipline system. So big thank you to Justin Ewart for bringing me up to speed in a short amount of time. And we will get started with the agenda. And first off, I want to make a call for public comment. So if there is anybody on the Zoom call or who has called in, please indicate your willingness to participate in public comment by the raised hand function or to use your phone to virtually raise your hand. I'm going to rely on Justin to identify those callers. And I would ask just to limit your remarks to 3 minutes so we can make expeditious use of everybody's time here. So call for public comment. Justin, do you see anybody?
Yes. GK client, I have unmuted or allowed you to talk. If you unmute your mic, you will have 3 minutes.
Hi, my name is Amber Galloway. I just stumbled on this meeting happening today, and I'm glad that I was able to make it. I'm one of the recent former clients of Girardi Keys, and my family has gone through a lot. It's been very traumatizing dealing with that firm, and just appreciate everybody's efforts in trying to make the victims whole and improve our legal system. And I'm not exactly sure what you guys are going to be talking about today, so I just wanted to let you know that I'm here, and if you want any insight on what it was like as a client, I am happy to chime in.
All right. Thank you, ma'am, and thank you for your public comments. Definitely appreciate your input as it relates to that very important ongoing issue. So thank you, and stay tuned for more information on this meeting. All right, Mr. Ewart, any other individuals?
No, there does not appear to be any other individuals at this time.
All right, let's go then to business 2A, which is the ENEC working group recommendations.
Okay, give me 1 second to set up because I'm trying to see the committee at the same time as I see the PowerPoint slides. Let me share my screen. Can everybody see my screen? Okay. Welcome, everybody. I appreciate everybody taking time out of their very busy day for this meeting today. This is the meeting of the Ad Hoc Commission on the Discipline System. A small tip, if everybody's in full screen mode, there's a little bar you can bring over so you can see. There's lots of people on this call, and if you want to see, kind of shrink the presentation, I will try and do my best to bring down the presentation when we're having discussions so we can have that discussion in person, but there is a bar to make the presentation smaller so you can see your fellow working group members. The agenda for today is ENEC working group discussion, expungement working group discussion. These first 2 working groups are farther along, and so they have recommendations that we will be discussing today. Ultimately, we will bring those recommendations in written form at the next full Ad Hoc Commission on the Discipline System for adoption. But these first 2 working groups have met quite frequently, and they've formed recommendations that we will be talking about today. The closed complaints working group discussion and progressive discipline working group discussion aren't as far along, but we will continue that discussion today and hopefully identify some areas for recommendation to bring back at the next meeting. And then the final agenda item is an update on the Committee on Special Discipline Case Audit. Our Executive Director, Leah Wilson, will be providing a presentation on that. The discipline costs agenda item was pulled. I think there's a little bit more work, and I will contact the working group to work on the discipline costs. And I think we have a robust agenda, so I'm not sure we would have gotten to it even if I didn't think to pull it to work on it a little more. But it will be brought back to the full Ad Hoc Commission at its next meeting. So a quick review. Since we haven't met in a while, this is the timeline that we're currently on. We had a lot of working group meetings September, and we're going to continue into next month with the working groups. Right now, we're focused on those recommendations. There's kind of 2 timelines. The final report is due to the Board of Trustees in June. The reason we're trying to expedite recommendations right now and potentially adopt recommendations when we meet again in late February or early March is so some of these recommendations may require changes that are legislative. And if we want to impact that change in a more efficient manner or timely manner, we need to get those recommendations in front of the Board of Trustees in March. Some of the other recommendations, you'll see that we aren't discussing recommendations from the diversion working group or the moral turpitude working group right now, because those won't necessarily have statute changes, but some of these other recommendations may have statute changes. And so in order to get them in this legislative cycle, we need to get them in front of the Board of Trustees in March. So this is the work that we have been doing. I just wanted to thank the commission for all of the work they've done. We've had 2 full commission meetings. This is the 3rd commission meeting. We've had 8 subcommittee meetings, and we've had 18 working group meetings. So in about 9 months, we've held 30 meetings with the different working group members, and you're all volunteers. And I really appreciate the level of effort that everybody has brought to this task. And I just wanted everyone to realize all the different work that we have done.
Hey, Justin, real quick,
Yeah.
if you're on the line here and have not muted your Zoom or the call function here, I just asked for everybody to review that. I think Mr. Farwell picking up a lot of background noise on your side.
Thanks, Brandon.
All right, thanks everyone.
And so the goals for today are to have a robust discussion and get a greater understanding from the topics. We had the working groups really dive into the topics, vet various different things, and then kind of coalesce around certain areas of focus and recommendations. And so this is to bring it to the full commission members, and so they get an understanding and we can have a discussion of what the working group, the work that they've done, and then potentially determine areas where additional information is needed to coalesce around recommendations. Our first topic is the ENEC topic, and if it will go forward. So the goals for the ENEC discussion, there are 2 main topics, focus areas. The first is, should there be an opportunity to hold an ENEC on criminal conviction referral cases? And the second topic that we will discuss is, should there be limits on the number of ENECs? I'm going to give a brief background because it's been several months since we presented the ENEC topic to the full commission on this. And then I'm going to turn it over to the working group members to tell you their thoughts on the recommendations that they have in regards to the ENECs. So here is a quick background on ENECs. The ENEC process, the purpose of the ENEC is to obtain a judicial evaluation of Office of Chief Trial Counsel's case. A settlement is a byproduct of that actual evaluation, but the judge basically gives the parties, their evaluation of the facts and charges. And so at this process, the original matters have the opportunity to have this process, but where we're focused here are the criminal conviction cases and opening up that avenue to those types of cases. Another brief overview of the settlement process. The notice of intent to file disciplinary charges is given to the respondent, and then the respondent has 10 days to request the ENEC. That red box, charges filed in state bar court, everything that's prior to that red box is typically confidential. It's once the notice of discipline charges are filed, that's when it becomes public. And so the focus of the discussion here is, should criminal conviction cases have the opportunity to have an ENEC and come to a private approval that would truly stay private prior to the charges becoming public, or the criminal conviction referral becoming public? When talking about the criminal conviction referral, there was a lot of discussion at the ENEC because, and I'll bring it up, the State Bar launched a fingerprinting project in 2018, required fingerprinting from licensed active attorneys for the purposes of receiving subsequent arrest notifications. This led to a lot of C cases coming to the bar that didn't originally come to the bar because we weren't receiving subsequent arrest notifications. And so there was a lot of discussion on, since we have a lot more of these cases, it would be nice if they could get an opportunity to have an early neutral evaluation conference. Now, this influx of C cases will be reduced. We will get through this initial backlog of Corey cases eventually, and we're a lot of the way through that now. And then we anticipate that it will go back down to the normal levels prior to this project, although it won't totally go back down to the previous levels because we will be receiving the subsequent arrest notifications. The reason this is an issue in the criminal conviction cases is due to Business and Professions Code 6101C. And this requires the Office of Chief Trial Counsel to transmit within 30 days of receipt those criminal conviction referrals that have the moral turpitude. And Business and Professions Code says to the Supreme Court, but that authority has been delegated to the State Bar Court. And so this time constraint here does not allow for the ENEC process currently for these criminal conviction cases. This chart here, the ENEC working group looked at, and this just shows that the criminal conviction cases were pretty steady and pretty minor. And then because of the fingerprinting project, they spiked significantly, increased 10 times in 2019. And so you can see that it's starting to come back down to where it normally was. But this shows that there were a lot more C cases in the last couple of years due to that project. And I want to remind everybody, if there's something that is unclear or you have a question, you can feel free to raise your hand at any time, and I'm more than willing to entertain it. It's meant to be an interactive discussion. And so this chart showed the committee that, you know, public and private approvals increased significantly. And so we're talking about private approvals in this recommendation. So this final chart really shows the number of people that we're talking about on the C cases. If you look at this chart, it shows the different types of discipline. And where we're focused on is the private approval, which is the green section of this chart. And so the green section of this chart, you can see, is very small. It's not, it's a couple of attorneys every year. In 2020, it's slightly bigger. And that's because we have those subsequent arrest notifications because of the fingerprinting project. If we didn't have those Corey arrest notifications, it was actually 2 attorneys. There's 12 total, but 10 of those were from the subsequent arrest, the Corey cases, and 2 were just the run-of-the-mill conviction transmissions. So whether or not we make a change, these are kind of the population of attorneys that would be impacted by this change. And so I'm going to stop sharing here in a second and turn it over to Ed and Steve and Melanie to discuss the different situations. But basically, should there be, what we're trying to solve and whether or not their recommendation should there be an ENEC opportunity for conviction cases? And like I said, the arguments in support are it allows for a private approval, like a truly private approval, because the transmission to the State Bar Court makes it public. But if we had a process to have an ENEC before the transmission to the State Bar Court or some other remedy, it could be a truly private approval. The other side we're trying to balance is if we have this process, it does delay in instances where it's not a private approval, you know, it potentially is public, the notification to the public, and that might require a statute change. So at this time, I want to bring down the slides, and the ENEC working group was Ed Lear. I would like it if you wouldn't mind kind of correcting anything that I said incorrectly, but also giving your point of view as to why you think that there should be an ENEC for criminal conviction referrals.
Thank you, Justin, and thank you to you and your team for putting together those metrics. I am a defense attorney, which will be clear from my comments if you didn't already remember that. I'm also the one that brought this to the attention of the commission, as I and Ellen and the ADDC thought and do think that it's an important issue. In classic defense attorney form, I think if there's even one person that's negatively impacted, that it's a worthwhile endeavor to change the system, which I do not believe is a heavy lift in this context. I was surprised at the very few number of private approvals that result from criminal convictions. I didn't expect such a low number. Certainly, part of my view was impacted and affected by what I call the fingerprinting cases, and you may remember that from the graph, where there were many more private approvals in 2020 than traditionally. So that's my background on it. I continue to be a strong advocate, as is the ADDC, of a rule change that would allow for private approvals in the context of criminal convictions. It's the right thing to do. It's the fair thing to do for those people. Beyond that, I want to talk about a couple of other things that came up in the discussions that we had. One is that in my mind, the whole purpose of an ENEC is to limit the number of cases that get filed and have to be prosecuted. And in that regard, there's a cost issue that's involved, not just to the system, but also to respondents. And so ENECs in general are a very effective way of limiting the cost to the entirety of the system and to my clients, because the whole point is to have an early neutral evaluation by a judge. And to give a little perspective there, with respect to what Ellen and I do on behalf of our clients, not all clients necessarily trust our experience and expertise, and they are looking to get a little more intel, so to speak, from a judge, from a sitting judge, who can tell them that Ellen is right or Ed is right. This is a private approval case, or that should settle, or this is a 60-day actual case. So the ENEC process is extremely valuable in a defense attorney's toolbox with respect to trying to resolve a case. And so I'm going to go beyond the private approval for criminal conviction and say generally that even when we're talking about a situation where there might be a criminal conviction that is an actual suspension case, it is an invaluable tool for us to go to an ENEC and to have a judge opine and give an early neutral evaluation as to what he or she thinks is the appropriate level of discipline. That helps us a ton with respect to trying to resolve a case. And again, goes back to creating a situation where there will be fewer cases in the prosecutorial pipeline, and also less cost to the respondent. And so I think for those reasons, other than just the issue of the private approval, that the ENEC process is a valuable process in terms of a settlement mechanism to ease the overload on the system. So for those reasons, I think that we need to have a rule change and advocate for same. Our committee, I think, was probably doomed from the beginning because we had an even number of participants in our subgroup. So we essentially tied at 2-2. So along party lines, I might add. And I didn't say that quite right. Judge Wang is trying to be as neutral as possible regarding this issue. Her comments generally were supportive of expanding the ENEC process, and Melanie and Linda can chime in if they disagree with that. But generally, we were tied at 2-2, and there is Judge Wang. And so we are here essentially to put out and set forth our positions to the group as a whole, and let the group vote as to how you all come out. We had very, very robust colloquies on this issue. I learned a ton, and I haven't changed my position, but I've been further educated about my position in a good way. And I understand now the position of OCTC in a way that I didn't before. So I think the process worked in that way. Again, I don't agree, and I couldn't convince Melanie, so here we sit. And that said, what else did I want to say? Those are there's another, so that's part one. Sorry if I'm over talking, but we did meet an awful lot of times. Secondly was the issue of limitation of ENECs. And again, there was a 2-2, and again, predictable party lines, so to speak, which is to say that the defense bar position, my position, is that there should be as many ENECs as are needed to resolve a matter, and that benefits my clients, Ellen's clients, and the system, because again, we're not overloading the system by putting matters into the prosecutorial pipeline in the court. And so for those reasons, I think that there does not need to be a limitation. I have had great success in resolving cases that have had multiple ENECs, and that's a very small beta test, so to speak, but that's been my experience. And my further experience is that the judges know what they're doing. So there's not a judge that I'm aware of that would set a second ENEC if he or she didn't believe that it was a worthwhile use of his or her time and a worthwhile use of the process. And I would say, maybe all of my multiple ENEC cases have resolved prior to filing. Why is prior to filing important, even in a non-private approval context? Again, cost, and cost includes the state bar cost grid, and what that means generally is that if a matter is filed, then my client, Ellen's client, will have to pay more to the bar based on the fact of a filing. So there's a cost saving to the client and a motivation to the client in resolving a case through an ENEC to save some money. And again, also to save money based on monies they have to pay to Ellen and me and our brethren. So for those reasons, I think there should not be a limitation on ENECs. I think that if one trusts the system, and here in an ENEC context, the system would be the ENEC judge, then one can feel good about a judge being the gatekeeper and not allowing an abuse of the system where there would be one or two or three ENECs that are somehow contrary to consumer protection. Those are my comments. Thank you for the time, and vote for me. Just kidding.
And I just wanted to provide two clarifying. I have a couple slides on the multiple ENECs after this. I was trying to just do the primary discussion on criminal conviction cases first. And I just wanted to remind the commission too that everybody volunteered for the working groups. And so there wasn't an expectation that there would be unanimity in the votes and balance of the different perspectives. And so that's why it's important for the commission to weigh in, because as Ed said, there wasn't a unanimous decision. In the other working groups, there wasn't a unanimous decision once we get to expungement either, because everybody has their own opinions, but it's going to be up to the full commission to look at that and say and adopt these recommendations. But we didn't assign necessarily the working groups to be balanced. They were volunteers who had knowledge and interest in the areas.
Right. So then, Justin, as a point of procedure, do we have recommendations today that we're going to be asking members of the commission to vote on, or is this more of we're going to put forth several potential recommendations? Staff will draft them, further study, and then we'll vote on them at the next meeting. How's that going to happen?
Yeah, that is the goal, is to have the recommendations in written form provided to the committee in advance so they can review it and adopt at the next committee meeting. But as you see, we have formed recommendations here. It's just this is the discussion part, and we'll formally adopt at the next meeting.
Okay. All right. So then, is there anybody else on the ENEC working group that would like to lend their perspective? All right, I see Ms. Lawrence has raised her hand. Good morning.
Good morning, thank you. Justin, I heard you say that you had a few slides related to ENECs generally, so I don't know if you want me to address both the C cases and the ENECs generally.
Well, I can bring up the slides. I can present on the multiple ENECs if you'd like. It's just two slides just to show.
Well, let's do that, and then I'll just get all my comments in.
Okay. I will share real quick on. Can you see my screen again? So this is just showing that the number of ENECs held and the types of kind of the volume of ENECs that have multiple ENECs. So you can see that, this was the breakdown with and without council. The ENEC working group wanted to see whether or not council made a difference in the ENEC process, and it did. This is kind of the volume with and without council. This next slide that Ron presented to the committee shows that with council, the settlement rate was significantly less than without council in terms of the settlement rate. But where we were looking at this was that the number of ENECs did not impact the settlement rate. So that wasn't statistically different whether or not you held 1, 2, or 3 ENECs, and whether or not you had there was a settlement that arose out of the ENEC process. So this was kind of a key finding, that the number of ENECs wasn't statistically different to impact the settlement rate of the ENECs. And so and then the final slide I have on this is just kind of the arguments that were in support and against. The multiple ENECs can delay public notification. If the offense is going to be public, there's nothing that prevents settlement after the ENEC. So the notification of the public could be delayed. And then the thoughts against this was it does limit the hearing judge's ability to continue the ENEC process and order multiple ENECs. And as Ed mentioned, the costs do go up the farther along you go throughout the process. So I will stop sharing. Those are the brief slides on multiple ENECs.
Okay, great. Thanks, Justin. Well, I do agree with Ed that we had some really great discussions, and I do think we've all have a better understanding of one another's positions. But a couple of things stand out to me about ENECs. And so to be clear, I'm from the Office of Chief Trial Counsel. And the purpose of an ENEC, if you read the rule, is that the judge must give the parties an oral evaluation of the facts and charges and the potential for imposing discipline. It doesn't say anything about settlement as being a goal of an ENEC. Now, that's not to say that it couldn't be a byproduct. And if we can get there, that's great. But that's not the purpose of the ENEC to begin with. And so when it comes to criminal conviction matters, these matters are always more expedited. And that's because there's already a record of conviction. So we have a starting point. We don't have to spend time working up a case and proving elements of a particular crime. Those are already there for us. And it's a matter of public record. So keep in mind that ENECs, and especially when we talk about them in the context of original disciplinary matters, are confidential. And the cases that are going to ENECs are all confidential. There's no public notice yet. Criminal conviction matters, as I said, are a matter of public record. So there's less concern then about the fact that about whether or not these cases are resolving at the state bar level prior to filing. So the other thing, and this is something that Justin talked about, is that we have a very limited time period between the time that we receive a certified record of conviction and when we have to transmit it to the review department. We have 30 days, and that's by statute. And we find, generally speaking, that ENECs can be terribly inefficient, quite frankly. I know that's a different perspective than others on the working group. But when you think about 30 days from actually receipt of a certified record of conviction to actual transmittal to the review department, if there weren't significant changes to both the rules of procedure and statutory changes, it's just completely impractical to think that we are going to manage to get all of these criminal conviction matters where someone might be requesting an ENEC in before a 30-day deadline. So that's obviously also one big consideration. And given those challenges and the changes that would be required, and the fact that, as Justin mentioned, it's really a very, very small number of people in the end where matters might resolve with private discipline, it just doesn't really make sense to us to invest the resources that it would take for the bar to actually make these kinds of changes. So that's one issue. I also want to just highlight the fact that we are always interested in settlement. And while it certainly is helpful at times to have the perspective of a judge, we get those opportunities throughout the process in any event. First of all, we're always happy to talk about settlement with respondents and respondents counsel outside the context of any formal proceedings with the judge, but also in criminal conviction matters, just like original disciplinary matters. There is always a voluntary settlement conference that's held during the proceedings before a case goes to trial. So there is an opportunity to hear from a judge about the strengths of the case and to potentially settle before it actually goes to trial. You know, I did hear Ed talk about costs, and it's true that costs do go up throughout the process, whether you're talking about a criminal conviction matter or original matter. And I know that costs are a concern. I understand they can be quite high. I do think that that's another conversation, though, to be had if we want to address costs separately. I don't think that that should drive whether or not there are changes made to the ENEC process. So the other thing, and talking about multiple ENECs, so this is separate and aside from the criminal conviction matters. As I mentioned, we often find that the ENEC process itself can be quite inefficient. And, you know, there are rules that require when the ENEC is supposed to be requested and when it's supposed to be set. But the fact of the matter is, you know, if matters aren't set within the time period of the rule, if they're not held within the time period of the rule, there isn't much recourse for OCTC. And the court is very interested in respondents having an ENEC if they want. And so we're often not successful if we end up actually filing a notice of disciplinary charges without an ENEC. The possibility really exists that those charges may be dismissed with an opportunity for the respondent to actually engage in an early neutral evaluation conference. The other thing to remember, as I mentioned, is that during the ENEC process, the matter is confidential. And when we are ordered to participate in multiple ENECs, and which has happened too many times, in our opinion, the matter then is confidential and the public does not have notice that the attorney is under investigation and potentially faces disciplinary charges. Now, the value of an ENEC prior to the filing of a notice of disciplinary charges really is if the matter is going to resolve with a private discipline. And that's the advantage to a respondent in particular. And we're interested in engaging in that process. Like I said, we do think that the judge's perspective is important. But if we're looking at a case where it's likely to result in public discipline, the delay in the ENEC process by requiring multiple ENECs in particular prevents the public from notice that the attorney is under investigation and potentially faces disciplinary charges. And we think that's important, and especially important if the case is going to resolve with public discipline in any event. After the notice of disciplinary charges is filed, again, we are interested in resolving the case by way of settlement, if at all possible, and we can have those conversations outside of formal proceedings with the court. There will be, and there always is, a voluntary settlement conference. So it's voluntary, it's called a voluntary settlement conference, but in any event, the parties go. And at that point, we get the perspective of the judge and try to settle cases. So we're really concerned about public protection when it comes to making sure that cases are moving forward timely and are filed so that there is public notice. And to that end, one of the things that we would like to see when it comes to changes to the rules related to early neutral evaluation conferences is really that the parties are only required to engage in one session of an early neutral evaluation conference unless the judge makes a determination that the case is likely to resolve with private discipline, which again is really the value to the respondent more than anything else. So that's where that's at least the perspective from OCTC. And again, it really was a valuable colloquy. And I just don't think that we're going to agree, unfortunately, on this issue.
All right, before I turn it over to any members who have questions, anybody else on the ENEC working group have a comment? Yes, Judge Wang.
Thank you, Brandon. Let me take my hand down. Okay. Just following up on a couple of points. I'm sorry it was late. I was in an E&E. So some follow-up to what I probably missed some of Ed's and and I heard all of Melanie's. One, I just wanted to clarify a couple things. Expunged cases come to us. So it's not completely accurate that conviction referral matters are public. So in a criminal court, your case can be expunged, you still come to us. Habeas petitions, that doesn't affect finality. So there is a subset of the matters that come to us that are not available in a public forum. So with that, I wanted to note, as well as the perspective that E&Es are only for an early neutral evaluation. It would not be efficient for the judges not to treat it as a settlement conference. So you have efficiency on the one hand, you have fairness on the other. This is the ad hoc committee on discipline with the view of fairness as well as effectiveness. So it isn't solely for the court to give its neutral evaluation, though that is an important function. For example, this morning in my E&E, OCTC was not ready to file. So this is where I'm going into the limiting the numbers. So it's an evaluation for OCTC to consider. So in this morning session, I said, you're looking at it from this standard. However, if you cannot prove X, Y, and Z, we're looking at this standard, which is a big difference between suspension and possibly a private reproval. So in that case, OCTC conceded they were not ready to file. And I offered my services, do you want a second E&E? They declined, and then I didn't hold one. So from my perspective, limiting the numbers or limiting the court's discretion to hold a second one is problematic, because you have to trust the judges. You have to trust the judge's opinion and the fact that it's not ready for filing. I never force any parties to come to a second E&E. So to me, this is legislating discretion in not an appropriate manner. So those were a couple of things I wanted to point out. And if I can circle back to conviction referrals, I would agree with Melanie that there isn't a need to hold an E&E if the judge was only looking at the elements of the offense. So what happens in the conviction referral process is the judge is looking at the facts and circumstances surrounding the conviction. It's not just looking at the elements and then deciding whether or not, based on the elements, we have disciplinable misconduct. We're looking at the facts and circumstances. And in fact, I believe it's already gone through public comment. I think the rule provision has changed. So OCTC may now do a deposition of the client in a conviction referral matter. To me, that's the flip. It's the other end of the E&E. So if there is a concession or an acknowledgement that OCTC needs more information to determine what the appropriate level of discipline is, based on this DUI conviction, do we need more discipline? Do we need something to protect the public? And we're looking at the facts and circumstances. And the fact that there is an acknowledgement or an idea out there that OCTC could benefit with further investigation, then on the other end, respondents should be entitled to an evaluation of those facts and circumstances and whether or not it arises as disciplinary misconduct. So I supported Ed's proposal for opening up E&Es for conviction referral matters, and I am against limiting the numbers of E&E sessions. Thank you.
All right, Steve Moad.
Thank you. Just two minor points. One is the 1203.4 isn't truly an expungement. 1203.4 is more relief that allows people to, in certain situations, say that they weren't convicted of a crime. It doesn't 86 the record, if you will. It's still a public record, and it will show that they have received 1203.4 relief. As far as the deposition goes, there are certain circumstances where OCTC needs additional records in order to, conduct further investigation. Although that opportunity, if, for example, that would occur during that ENEC, then that may be some value there, but that wouldn't occur during the ENEC. And frankly, the opportunity for the respondent to get that additional weigh-in from the court about the evaluation would only be beneficial after that deposition had occurred and OCTC had all of the facts and circumstances of the case. So I'm not sure that those two things are exactly aligned. I certainly understand the judge's point, and it does make sense, but there would need to be a substantially contemporaneous for those two things to occur.
All right, any questions? All right, I see Ms. Pansky has her hand raised. Oh, you're still muted.
Thank you so much. I don't have questions, but I do have some comments, if that's permissible. So I think I'm probably the only person on this commission that was employed by the State Bar and or doing State Bar work, State Bar court work before the ENEC process was adopted. When I was first a State Bar prosecutor in 1978, if you'll permit me to give a little bit of history, we had a much different system. And in the old system, which was patterned generally after the criminal defense and prosecution system, we would have what was called a preliminary hearing. And there would be a hearing prior to the filing of any notice of disciplinary charges, and there would be a judicial officer who made the decision what to charge. And later, when the Supreme Court adopted the full-time professional State Bar court, everything changed. There was a commission that studied the discipline system, however, 20 years ago. And at that time, Justice Elwood Louis recommended the adoption of the ENEC system patterned after the federal ENEC system. And I have to respectfully disagree. The purpose of the early neutral evaluation conference was always to permit a judicial officer to evaluate the case and to make an effort to see whether the parties could come together and resolve that case prior to the filing of disciplinary charges. So we can parse out the words in the rules that adopt an ENEC, but the true fact is that it was always intended to be a process to gain an early resolution of the potential charges against a respondent with judicial assistance. And in my view, that's what it should be. I have to say, as I've said in my own working groups, I was not on this particular working group, that frankly, the data does not jibe with the anecdotal experience that I've had over literally 45 years. And the reaction of the members of ADDC when Ed and I share the data is pretty universally extreme surprise. So I do not know what whether the data that's been collected for the graphs and the charts that we just saw are statistically significant. But in my experience, a high percentage of cases settle at the ENEC, where the respondent's represented by counsel, not a low percentage. So I am surprised about that. But as Ed said, even if it's a small percentage, there is a significant impact upon a respondent financially, not just because of the cost. And I don't think that the cost issue can be or should be divorced from the issue of fairness in giving the respondent an opportunity to settle a case early. And it's also defense costs. And a lot of lawyers who represent themselves in a disciplinary proceeding do not understand how the process works. And many of them, and I think that the judges will bear this out, come into the ENEC underprepared. They don't understand that they have to have all their mitigation fully developed. They don't understand how to research cases. I wonder whether a high percentage of cases settle where the respondent is unrepresented because they have not done the research. I'll give you one example. I happen to have had an E&E yesterday with Judge Wang, and I presented a case. It's a published review department of the State Bar Court case, which talks about how you analyze a second DUI conviction for purposes of discipline. I assure you, my client knew nothing about that case and would not have presented it at an ENEC. And partly because of that, and partly because it was recognized during the ENEC process that there is additional mitigation, and it would be fair to permit the respondents a couple of weeks to put additional evidence together, that a second ENEC was scheduled. There's a theme that I hear, and I'm going to be revisiting this in future commission meetings, in my working group and in the other working groups and the presentations that we hear at the full commission level, that nothing should change. Nothing should change. We can't change anything because it will adversely impact public protection and or it will cause delay. I don't accept that. I don't believe that's true. Typically, if the judge recommends or suggests a second session of the ENEC, it's a delay of a couple of weeks, 2 weeks, maybe 3 weeks. This is not a major delay. And it's particularly not a major delay when compared to how much time the Office of the Chief Trial Counsel takes, OCTC takes, when deciding how to develop its case and how long to wait before filing. It is not an appreciable delay. It simply is not. The other thing I think that needs to bear mention here is the reason there was that spike in conviction referral proceedings that you saw on the chart is that when the re-fingerprinting occurred and the new information was brought forward about convictions, many of these were very old. I mean, between 10 and 20 years old. So when you're talking about public protection, in many cases, you have a lawyer who was convicted of DUIs, typically 2 DUIs, some long time ago, 7 years, 10 years, 15 years, 20 years, literally, I'm not exaggerating. So again, I question, what's the public protection issue when you have people who have not had lawyers who have resolved their problem, they've been rehabilitated, they have had no other discipline in an extended period of time, and how much of a public protection issue are we really concerned about to give this person a few extra weeks or a month to be able to come back and say, okay, you want me to get 3 more character reference letters? I'll do that. You want me to go back and dig up my old records to show that I went through a substance abuse education program 5 years ago, 7 years ago, 10 years ago? Okay, I'll go back, I'll do that. I mean, it's a fairness issue. I, in my experience, find that cases do settle at the E&E level. And I do think it's a significant adverse impact on a respondent to have to go forward now and do discovery, have to maybe file motions, and attend another settlement session anyway, which is a VSC. So if OCTC is saying, oh, well, you really don't need it because you'll attend another settlement session anyway later, why don't we front load the process and get rid of these cases earlier, make them more efficient, remove some of the burden on the courts, and make it less expensive and fairer for the respondent? Thank you for listening to me.
All right, thank you. Ms. Good.
Hi, let me try and lower my hand here. Well, this has been really an enlightening discussion, and I certainly have appreciated hearing the judicial perspective, OCTC's perspective, and also the defense bar's perspective. I had sort of two questions, and I will say, you know, E&E is very common in the civil context, and I personally have served as an E&E evaluator in federal court, and I know that often it can start a dialogue that leads to a resolution, you know, whether or not it itself is resolved. So I had a couple of questions. One was, is it possible to split the baby here and have OCTC and the defense bar kind of come together and agree on some sort of subset of criminal convictions that should go through the ENEC process? So that was kind of one question, and maybe it's simply a yes or no and nothing in between, but I thought it would be worth exploring. And then secondly, I wanted to understand the OCTC's point about delays in terms of having multiple ENECs, and then the delay that results in terms of public protection issues. I know Ms. Pansky just said there's not much delay. There's like a 2-week interlude. I just wanted to understand, as a logistical and practical matter, you know, what that looked like. Are we talking about 9 months? Are we truly talking about 2 weeks? You know, what does that look like? And that's it. Thank you.
All right. Anybody on the ENEC working group want to address those?
Well, if I could just answer Ms. Good on the delay issue. So just keep in mind that, and I'm sure you'll appreciate this, that it requires first the respondent to actually request the ENEC, then the court to actually find some time to schedule it. And typically speaking, it's the same judges who are, you know, conducting trials, for example. So they have a trial calendar to deal with. And then you have respondent and potentially respondent's counsel to try and find dates that work. So while, like I mentioned, the rules have, for example, the state bar court hearing judge will conduct the conference within 15 days of the request. I don't know how many of those actually are held within the 15 days. I imagine that some of them are. I think that probably some of them are not, just because of all of the logistics, and certainly that could be on OCTC's part as well. But I don't know that we even have data to specifically answer your question about, are we really talking about a matter of weeks or a matter of months? I can tell you anecdotally that given the logistical challenges to scheduling even the initial ENEC, that there are similar challenges to follow-up ENECs. And I do think that there is data on how many ENECs have been scheduled in particular cases. Sometimes it's 2, sometimes it's 3. And so you're talking about, I would suggest, not a matter of just weeks. In some instances, it could be a matter of months. And the entire time that's going on, the notice of disciplinary charges cannot be filed. And that is the first public notice that there are charges pending. In addition, and this isn't something that we've talked about already, but it's certainly something that's on our minds, is that, you know, OCTC is supposed to be resolving cases within 180 days of when they walk in the door. And it's something that is has highlighted regularly by state auditors and the legislature. I know they're concerned about it. And the longer that this ENEC process goes on, the longer our cases are in that process, because those days are counting against us until that notice of disciplinary charges is filed.
I have some answers for Sarah as well. Sarah, thank you for your questions. They're very thoughtful, and thank you for listening. I think an important point from the defense perspective is that this issue is not limited, excuse me, to how it started, which was the concept of private approvals. The ENEC process is a very valuable tool to resolve cases early, to decrease clutter in the system, and to decrease costs both for the respondent and for the administration of justice. So to say that we should hypothetically only have misdemeanors in the ENEC process and not felonies that are not involving moral turpitude, that would be maybe a simple delineation on one level, but on another level, the defense bar's position is that a felony without moral turpitude is resolvable at an ENEC level where we would decrease costs and decrease clutter. And I used that example earlier of a 60-day actual case. Those get resolved at ENECs all the time. And I think that the important distinction here is that the position to allow C cases in ENECs and no limitations on ENECs is not limited to those 2 to 4 cases a year that are the privates, which is what the graph showed. Again, I was surprised by that, but nevertheless, the argument here is not limited to that. It's limited to facilitating the administration of justice, decreasing costs. And so I don't think that there is an easy delineation in terms of carving out certain criminal convictions and not others. I will also add for the group that in one of our working groups, our most recent one, there was a nice discussion about, okay, we have our set positions. What can we do to split the baby, to use your term? Is there any way that we can come to some kind of compromise to make this not the best solution for either one of our respective sides, but at least a solution, a something, so that we wouldn't be taking your time now, pitting ourselves against one another with two very disparate positions. We tried, and we really didn't make any progress on that, because it's a pretty binary argument, and so that's where we sit. But we are very mindful of having tried to compromise. We couldn't do it. Maybe one of the geniuses on this call can figure that out, but we couldn't. So thank you.
All right. Speaking of geniuses, I think Mr. Saleg was up next.
Oh, that's funny. So on the timing of the ENEs, whether to have more than one, I think OCTC has some valid points about the delay issue, and I think we need to be mindful of that. I would think that in terms of whether a second ENE unfairly delays the publication of the charges to the detriment of the public, that's something the judge can decide in individual cases. And so I think OCTC can make that argument in appropriate cases to the judge that there shouldn't be a delay. But I wonder if there is a compromise here, because it does sound like there is often a need for a second ENE, and it's useful, in part because the respondent comes to the first session unprepared if they don't have counsel, or not fully prepared. So I wonder if we could have a compromise where we have a rule that, or we propose a rule that says, if there is to be a second ENE, it should be no more than 15 or 30 days out, and that for a third or subsequent ENE, the judge must make a finding that non-public discipline is reasonably likely. So that would be a bit of a compromise that we might consider.
Right.
Sean,
any responses to that?
I do have a response, and I thank you for thinking of a creative solution. I think in practice, it's not as easy as it may sound. So when there is a second E&E that is on the table, again, we've got the gatekeeper, the judge, who thinks that there's value to having a second E&E because of things he or she heard that suggests that compromise may be appropriate. Oftentimes what happens is that there may be a need for mitigation, character reference letters, or other types of mitigation. It sounds really easy to pull together, but Ellen knows, I know that it doesn't happen as fast as we would all like it to happen, number one. And it's not always on the respondent side that the respondent has to go back and do homework. Sometimes it's on the OCTC side, which is the judge may say something like, well, I think we need a little more legal research on this issue, and could you go back and do that? Or could you go back and look at your evidence and tighten it up, or go speak to another witness or something like that. So it happens both ways. The idea of limiting the time within which to have the second E&E is fine in concept. The 15 to 20 days, I don't think is practical. I think perhaps 2 months could make it work. So that's one comment. On the other one, which is limited to 2, unless there's a probability or possibility of a private that coming through on the 3rd. I based on my experience, I'll tell you about one of the harder cases I handled, where it took 3 E&Es and almost a year to solve that case through the E&E process. It ended up in a public approval. It was not a private approval, but the case started at a disbarment. And so there was a lot of heavy lifting in order for us to get to that point. And it was through the discretion of the judge, who believed that there was a possibility of settling if certain things were shown over the course of time. It worked. I can't say that happens often. It's probably the only time it's ever happened for me. It was a very, very long E&E process where it worked. And ultimately, we were able to present the E&E's court, or the E&E judge, and OCTC with the appropriate amount of mitigation and facts and whatever else they needed to better understand what was a very, very complicated case. So I like the creativity in your solution, but I think it's not necessarily practical in context. I go back, and maybe this will be my final comment, because I think Judge Wang said it best. The E&E process is all about trusting the judiciary. They are the gatekeepers. I've had judges say to my request for a second E&E, no, this thing needs to be filed. If you want to take it to trial, that's your prerogative. But it's not always a yes when we request a second E&E. And when they do give a second E&E, it's usually with pretty specific aspirations as to what they want either side to bring to the second E&E, so that it will be a meaningful process in order to try to resolve it. So my last comment, trust the judiciary on this one. They're the gatekeepers as to whether it's appropriate to have a second, third, fourth E&E, and just that. All right, thank you.
All right, I think I see Melanie. Is that in response to this issue?
Yes, just really quick. I just want to highlight that, there are a number of attempts along the way in our process to highlight for respondents the importance of gathering mitigation, for example, and looking towards the ENEC process prior to filing. So to the extent that the ENEC itself is educational for the respondent, and the ENEC and the respondent comes to it without preparation, and I recognize that's a problem, but I do want to be clear that in trying to address that problem, for example, when we move cases out of investigation and into our pre-filing status, and that's where we're going to engage in the ENEC process, we do send a notice to the respondent letting them know that we are moving their case forward, and we highlight for them, this is the time to start gathering your mitigation, to tell us what your defenses are, etc. And then when we actually send the notice to say, okay, we're getting ready to file, and this is your opportunity to request an ENEC, we do the same thing. So there are opportunities along the way for the respondent to educate themselves and educate us. And I think that the court has been working on developing some self-help materials as well. So it is an issue that we recognize, and we have been trying to resolve it. But short of that, I'm not sure what else we can do.
And sorry to impose, Judge McGill, I think you were working on some of those materials. Do you have anything that you can update the commission on?
Thank you, Brandon, for bringing that up. Well, unfortunately, things have gotten a little delayed. The departure of Judge Purcell and me working as the acting presiding judge, we've had a little bit of an unexpected delay here. But the work is continuing to move on, but it is moving at a little bit slower pace than what I had anticipated and announced at the last time that this discussion was brought up. If I could also make one point, if I may.
Definitely.
And looking at, and I understand OCTC's comments on public protection. I'm not too sure if Ed had already said this before, because I had to turn my attention away when Ed first started talking a few minutes ago. But on the issue of public protection, I think one thing to look at is when we receive notice of a felony conviction, we do have to put the respondent onto interim suspension. And I think if there's a way to keep that process going while the E&E process continues, that might be an interesting way to bifurcate and solve what I think OCTC's, I'm making a bit of an assumption, and I don't want to on make an assumption on what Melanie is saying, but I think that might be one way to solve a lot of the public protection concerns that OCTC is having, because once they're on interim suspension, then a lot of the pressure, I think, is off on the public protection aspect of it. Melanie, I might be misunderstanding kind of your point, but that's kind of one thing I thought maybe a way to solve the problem is by looking at continuing on with the interim suspension process and then allowing the ENEC process to continue, because I do think as much judicial discretion should be given, because I think it does result in a successful education process, evaluation process, and ultimately a settlement process. Thank you.
All right, Melanie, you have your hand up to respond? Okay. All right, any other questions on this topic? Ms. Rosenblatt, I see your hand is up. Is it in regards to this topic? Oh, you're unmuted.
This goes back to a threshold issue that Ellen Pansky raised, and I may have missed this before, but I just wanted to ask if the determination of an ENEC has anything to do with the severity of the offense. Is it, I mean, because I have not heard reference to the seriousness of, the relative seriousness of a criminal charge. Ellen brought up, a series of alcohol offenses or drunk driving offenses. That to me would be quite different from Michael Avenatti's, a charge against Michael Avenatti for defrauding his client, Stormy Daniels. So I'm just wondering what has there been a prior discussion of the severity, a scale on the severity of offenses that might have fallen as criminal charges against an attorney? And as Judge McGill says, what are we protecting the public from? A client with a bad, drunk driving record, or from something much more serious that could impact their actual behavior as an attorney presently?
Okay, who would like to address that, if anybody?
Well, I guess I can see if I can address it. I mean, I think one of the things that we may be losing a little bit of sight of is that regardless of the severity of the crime, by statute, we have to transmit the certified record of conviction to the review department within 30 days of receipt of the record of conviction. And that transmission is when the matter then becomes a public matter for purposes of state bar proceedings. So that's the world that we live in that 30 days. That statute doesn't really distinguish. And the issue is really then if we were going to engage in an ENEC process in criminal conviction matters, regardless of what kind you're talking about, how do we manage that within the 30-day window? And part of the issue too is that while we have the certified record of conviction, and this is what Judge Wang was referencing earlier, the final resolution of those cases in terms of the level of discipline is driven not just by the conviction itself and the elements of the conviction, but the facts and circumstances surrounding that conviction. And sometimes it's, and in fact, oftentimes it's not evident what those are from the certified record of conviction by itself. We need things like the police report, for example. We need sometimes things from the respondent, which is why we were interested in having a deposition of the respondent. So it does take time to sort of develop that. And in some ways, we would be remiss in resolving cases early without sufficient information, when it could really be that this is more serious situation than the actual conviction would suggest.
Okay, I think Sean was next.
Thanks, Brandon. So going back to the topic of second and subsequent E&Es, I just thought about whether to talk about, I do want to respond to Ed's comments. So I think the idea of imposing some kind of policy limitation on more than one E&E does not reflect a distrust of the judiciary in any way. But it's a policy statement. And under our current rules, the first E&E is supposed to take place within 15 days, which I know doesn't happen all the time. But that rule transmits a policy that these need to be done promptly. And we do have a statutory directive that these cases are supposed to be resolved within 180 days. And whether we think that's realistic or not, that is the legislative policy. So I think our rules have to reflect a need for expedition where possible. So it's not like the review department's going to issue the equivalent of a writ every time an E&E isn't scheduled within 15 days of the request. And similarly, if we put a time limitation on a second E&E, at the end of the day, the judge is going to have discretion, but it would reflect a policy from the board consistent with statutory direction that these cases need to be moved promptly. So I think the concept of the second E&E being 2 months out is way, way too long and inconsistent with our statutory directions.
All right, I think Ms. Pansky was next.
Thank you very much. I just would like to clarify for Eloise a couple of points. So first of all, if a lawyer is convicted of a felony involving moral turpitude, that's a summary disbarment matter. So that is not part of the equation. That lawyer will not get a hearing at the state bar. They will be disbarred without a hearing. So the most serious level of offenses are not in the category that we're discussing here today. But there are some felonies that often involve domestic disputes. Sometimes there are cases where the lawyer might have some mental health issues. For example, sometimes there are shoplifting cases where there's a causative relationship between the conduct and a legitimate, verified mental health issue. So there are other categories that, while they are serious, they're sometimes mitigated, or they're extenuating circumstances that the respondent, should have an opportunity to demonstrate. I want to make one other point, and that is if you look at the statute that requires the transmission of a conviction to the review department, in fact, what the statute says is that if the crime either involved moral turpitude or there's probable cause to believe that it involves other misconduct warranting discipline, then it must be transmitted. There is a discretion built into that statute. Not every single conviction is mandated to be transmitted. So I think there's a bit of a misunderstanding. It's not the case that every single conviction must be transmitted within 30 days. There is flexibility there, as there should be.
All right, Ms. Bell.
Thank you. And what Ellen just said might change my question or comment on this, if that's the case, and if the bar is not actually transmitting all of the cases because of that discretion. But in any event, it did seem like from the previous comments that the one thing everyone that spoke from the committee or the working group seemed to agree on is that this timing, this 30-day time frame isn't really workable. It doesn't really make sense. And so I don't know if there's an ability, what the sort of, stomach people have for trying to get a statutory change for that, because it seems like, why are we treating these cases so differently from the other cases? Why are the C cases so different that we, have to not allow for a process that we allow in other cases? Kind of just going back to the initial question of what, are these cases so different that they shouldn't get an E&E? And it doesn't seem like that's the case. I mean, it doesn't seem like there's a good reason why we wouldn't want to give an E&E in those cases, except for it seems like there's this ridiculous time pressure. And I guess then the follow-up question is, if we don't have the stomach to try to get a statutory change, or that doesn't work, then what would have to happen for us to give an E&E in those cases? Like, we'd have to give those cases priority or something, or we'd have to limit them only to one E&E or something. I don't know if any of those, if those make sense, any of those possibilities, but I guess those are the things I'm struggling with, is like kind of understanding, like, if this time frame just doesn't make sense, then should we try to do something about that? If that's really kind of what one of the main issues is here. Thank you.
Okay, Steve, I see you have your hand raised. Is it in response to that? Okay, go for it.
Thank you. I'm having trouble lowering my hand and unmuting myself at the same time, but thanks for your patience. That's a great point, actually, about the timing, Ms. Bell, and we did seek to extend the time. And in fact, the 30 days was the legislature's response to our request to extend the time. It had previously been 5 days. And we asked for the statute to instead provide us a reasonable time. And the most that the legislature was willing to provide was 30 days. So that's not to say we couldn't go back and ask them for more time now, but that was relatively recent. I want to say it was in 2019 or even 2020. 2018 or 2019 went into effect in 2019 or 2020. So I don't know that would be successful, but it's possible.
All right, Mr. Larkin.
Thank you. I've been really enjoying this colloquy, this discussion. My reaction from having a pretty good handle on what happens across the country and not in the world in which you live, as Melanie mentioned, is that flexibility has to play a role here. And I know my own state of Illinois, I know other states don't bring public or even file a charge on a DUI or a second DUI. And of course, you have your own precedent and own directions. But I think flexibility is key here. So since we don't bring every conviction public, even though there's a public record that a citizen could find, we don't think that's a public protection issue, that our record doesn't match the public record of a criminal court. We think our public protection issue goes more to what I've heard here, which is, as an example of a second time DUI, a lawyer's been convicted twice. Is that lawyer fit to practice? And if we are persuaded that there is treatment and that lawyer is in recovery and that was the reason for the DUI, we wouldn't bring it forward. I only offer our unique experience or our individualized experience in Illinois because I just don't think that the filing publicly in our system is critical to public protection. What's critical to public protection is that the lawyer is not a threat to future clients. But I enjoyed the conversation. It was to me, in terms of the early neutral, I would come down today, just hearing what I've heard today, suggesting some flexibility. Just my 2 cents.
All right, and mindful of the time, I'm going to take comments from a couple more people, but then have a couple suggestions. So, Ms. Lawrence.
Yeah, I just wanted to clarify, and it's actually following up on Ellen's and Jerry's comments. I do want to be clear that we do not transmit literally every conviction. So the first time DUIs, for example, unless there are aggravating circumstances, typically would not be transmitted, because what we're looking for is cases that could result in discipline.
Oh, I think there's a glitch in the matrix, and we may have lost Melanie. Melanie, can you hear us? Oh, Melanie, you broke up there. All right, is anybody else having trouble hearing? Okay.
Yeah.
All right. Okay, I'm going to move on to Ms. King, and then once we get Melanie back, we'll finish her comments.
Hello, thank you. I had a question in the difference between, well, first of all, why wouldn't the public be able to make the decision on how they judge if somebody's in a position where they have 2 possible DUI convictions? And then secondly, if you're comparing the treatment between the attorneys and the public, what is the difference? If the private citizen is being charged with the same criminal activity, are they awarded the same opportunity with an ENE?
All right. Anybody want to take a stab at answering those questions? I know, Steve, you have experience in the criminal world, so I don't know if you want to address those.
Sure. Just to be clear, our office is not, and the state bar is not involved in prosecuting discipline cases for non-attorneys, in the sense that we would be bringing a case based on a DUI conviction, for example. And so in that sense, there is no ENEC, and there's no discussion about an ENEC in those circumstances. In the criminal world, where the underlying conviction is being litigated, or the underlying DUI case is being litigated, there also is no ENEC, although there are other terms that apply to other conferences where people get together to discuss settlement, whether that's a pretrial conference or a settlement conference, or whatever it is. There are opportunities for criminal defendants to meet with their attorneys, with the district attorney, and or with a judge to have a discussion about potential resolution of that case.
And Steve, just to put kind of a finer point on your point, and then I have a question, and I think maybe Sarah Good, if you could respond to this, seeing as you have experience. In state court prosecutions, there's no requirement that there's any sort of ENEC prior to the filing of criminal charges. After criminal charges are filed, usually there's a pretrial conference, And then if the case confirms for trial, if it's a misdemeanor, usually have a readiness. Felonies, usually there's a settlement conference before the prelim. And then if the case is held to answer, then before trial. But on the federal side, I'm not very familiar with any rules that govern how ENECs are set as far as any timetables. Are there any statutory guidelines or like federal statutes, any cases on point that limit the court's discretion or give guidelines to what constitutes good cause, and then the links of those continuances for their ENECs?
Mr. Stallings, I think I can answer your question. In federal court, the litigation has been initiated. And so ENEC is on the menu of ADR options for the parties to select. And there's a bunch of different options. And if you select ENE, then you go to a volunteer attorney in that particular area who has a conference and does an evaluation of the case, which often leads to settlement discussions. So it already is an active case, and it's just on the menu of ADR kind of options to try to reduce, the burden on the courts and to resolve things in an efficient way.
And I've heard that in federal, like criminal prosecutions, there's oftentimes a settlement conference prior to the filing of charges, kind of like that last chance to resolve before the charges become public. Has that been codified in any way, or is it more of just is it up to each individual district court on how those are handled?
I'm afraid that's kind of out of my jurisdiction. So.
All right. Okay. I see a couple of raised hands. Let's see. Anybody have a response to either Ms. King or myself on our questions, or is it to raise other issues? Okay, I'm going to go with Ms. Pansky first.
Really quickly, I just want to make sure, Ms. King, what we're talking about here is whether or not after the conviction, there should be a new and separate proceeding to discipline the lawyer. So not, as Mr. Larkin pointed out, not all states have a system like we have here in California, where after the lawyer has already received the penalty or sanction that's imposed in the criminal court, which is the same sort of sanction that the non-lawyers would get, now the lawyer has to face a licensing disciplinary proceeding. So a lot of states do not, I don't want to say automatically, but do not impose this new second level of discipline on lawyers, because the theory is that they've already been through the criminal system and they've already gotten the appropriate sanction there. And so if the conviction has no connection to the practice of law, then some states say, that's it. We're not going to impose a new penalty on top of the lawyer in addition to the penalty they've already gotten. So that's why it's kind of apples and oranges.
All right, thank you, Ms. Pansky. Mr. Cardona.
I can try and answer the question about federal prosecutions, but in federal prosecutions, it would be very rare, highly unusual for a judge to be involved in pre-filing settlement negotiations. Those are basically left to the prosecutor and defense attorney to engage in, and it would be an extraordinary circumstance for a judge to get involved and would have to be basically at the request of both parties. And then similarly, there's no set procedure in criminal cases for equivalent to what Ms. Good was referring to on the civil side for being referred out to a settlement. That again is something that's typically done at the request of both parties and is fairly unusual in criminal cases. Again, most of the discussions are left to the attorneys in the criminal cases without the judge participating. And in part, that's a function of Rule 11 that basically limits federal judges from participating in plea discussions.
All right, great, thank you. So just to kind of get a temperature of members of the committee, is there a consensus that we maybe have both sides of the ENEC working group put forth some proposals, send them to staff, staff compile them, conduct any further study that needs to be conducted, and then at our next meeting, this commission would have an opportunity to vote up or down those various proposals. Anybody have any strong objections to addressing it that way? Would that be, yes, Mr. Slig?
Well, I don't have a strong objection, but I wonder, Brandon, if it would make sense just to try to get a sense of the commission's view on these issues. It doesn't have to be binding. Sounds like what you're proposing, but at least a straw poll or something. So that would give staff it would give the working group some direction on what to come back with.
Okay. All right, so as to the first issue involving the ENECs for the criminal conviction cases, I guess, is it the will of the committee or the commission to further explore a potential statutory change, recognizing that that's up to the legislature, and that the state bar has legislative priorities that it manages? Is there appetite on this committee to pursue that potential statutory rule change? And if I could just have if you are in favor, please raise your hand in the Zoom function.
Brandon, can I clarify? Can you restate the proposal again? I think I missed part of it.
Okay. So the commission, members of it, is there a appetite for them to recommend that the state bar add to its list of legislative proposals that is pursuing a potential statutory change relating to the ENECs relating to the criminal conviction matters, and basically extending out? It sounds like we're going to need an extension of time from that 30 days in order for us to be able to complete the ENECs. Or Sean, does that answer your question?
Yeah, it does. So I'm raising my hand to indicate support for the proposition.
Okay. All right, so
let me just take, okay. Because even if you're off camera, I can see it in the participants list. So there seems to be a majority support for that position.
Okay.
And I just wanted to take time to recognize Ms. Schneider. She was the fourth member of the ENEC, and she was the only one that hadn't been intimately involved in the process. And I think she was very valuable during the ENEC discussions. And so I just wanted to recognize the fourth working group member and the role that she played in vetting a lot of these recommendations.
All right. Thank you, Ms. Schneider, for your work on that. Is she on the call? And I'm sorry, I don't see her name on the.
Yes.
Okay. Ms. Schneider, is there anything that you wanted to add? I think you're the only person we haven't heard from.
I thought the points were covered very well by the other participants, so I didn't chime in, and also in the interest of time. But just to let you know, I was against the proposal to include ENECs for criminal cases. And part of my thinking on that was simply that it had not been provided for in the first instance. And I imagine that's probably because in a criminal case, there's already been adjudication of the underlying conduct. So it's kind of different than all the other kinds of cases that come before the board for discipline, where nothing has already been determined. So that's just one point, but many of the points have been made, so I didn't want to add to the time.
All right, great. Thank you for your comments. The second item on this would be whether there is an appetite for the commission to propose rules relating to ENECs. And so I guess the first, I following in line with what Sean Selig said, as far as having a rule change that would indicate a policy relating to timeliness of how the NEC process should work, whether that involves the limiting the number of ENECs, limiting the time frame, and setting forth perhaps some issues, some reasons that the court could rely on, further reasons that the court could rely on in exercising its discretion. Is there appetite from this commission to explore, I guess, a codification of those rules and to have staff draft some of those limits, or maybe not limits, but just different factors for the court to take into account? And if so, please raise your hand.
Okay. There appears to be a majority.
Okay. So then secondly, do we want to have members of the NEC working group individually come up with proposed rules, and then those can be voted up or down, or sent to staff prior to, and then sent to the rest of the commission with the idea that we would vote up or down whether the commission as a whole recommends them to the Board of Trustees? Anybody disagree with that process strongly? Justin,
I
does
just
that?
have a comment, which is that that was our goal to begin with, and we didn't get there. So, I mean, this has been a nice discussion. Hasn't changed my view on that I had already articulated, and I'm confident that probably out of the four of us, nobody's view has really changed. So, Brandon, I'd love to say that we're receiving really clear direction as to what you'd like us to do. But I don't think it's any different than the instruction we had before. So maybe others on the working group disagree with me, but I think we're at a bit of an impasse.
And so I guess my challenge then to the ENEC working group would, if the two opposed groups want to come up with their own separate proposals, and then those can get sent to staff, and then they can be voted up or down by the commission at the next meeting.
I think that makes sense.
Justin, does that work?
Yes, I may involve some other commission members because we talked about specific things at the ENEC working groups, but we've kind of come up with alternative ideas here in terms of policy statements. And so I may workshop it with some of the other members of the commission to come up with ideas.
Okay. Any strong objections? Anybody else to this process? All right. Justin, anything else that we need to handle in regards to ENEC working group recommendations?
No.
All right. Should we go? I would note that we've been going for about an hour and 45 minutes, approaching the lunch hour. Do we want to get into the expungement working group recommendations, or break now for people to grab some lunch and then have a working lunch?
I know a couple of our members have a conflict from 12 to 1. We were trying to do lunch then, but it's up to the committee. We can break now and come back at 12:30, or what majority rules on this. I know some members have a conflict between 12 and 1, but we can do whatever the majority wishes. The expungement debate, it will be equally as, I think, substantive as this previous debate, because we are talking about expunging what is publicly available on the website, and then also a formal expungement process for the discipline. So it is another meaty topic.
The individuals who can't be here between 12 and 1, are they involved in the expungement working group?
No.
Okay. To those who can't be here between 12 and 1, are you okay if the committee pushes forward, just recognizing the limitations of time and busy schedules?
I see not. Yes.
All right, seeing no. So let's get started then with this this portion of the presentation. I say let's break at what, 12:30? Or do you think
Okay.
break at noon and then resume at 12:30?
Whatever the chair.
Yeah.
thinks.
Let's keep pressing forward. We'll break at 12 and then we'll resume at 12:30. Give people a chance to get some food and then come back.
Okay. All right. Can everybody see my screen? I'm sharing again. I see a nod. So the goals for the expungement discussion: should there be time limitations on how long discipline appears on an attorney's profile page on the State Bar website? So this discussion is really in two parts. One is what is publicly available on the website. This does not mean that, it isn't publicly available by calling in or coming into the bar or finding it by other means. This is just purely on what is on the attorney profile page on the State Bar's website. And then the second part of this discussion is about a formal expungement process. Right now, there's a way where you can expunge the records, but as you will hear, it's not used basically at all. And so there's not really a formal process for this. And so the working group really discussed these two things in detail. I guess this slide was to basically talk about the main points of the expungement, publicly disclosed versus the expungement process. So we're going to first talk about publicly disclosed and available on the website. Previously presented to the full ad hoc commission and posted prior, there was an Office of General Counsel memo in July of 2016, and it talked about the requirements of the State Bar and what it needed to post online. And it basically stated that the State Bar does need to have the discipline of record available. But the memo went on to say that is not specifically required to post public discipline online. So it's not required to have it on the website, although it tends to promote transparency and facilitates the public's right of access to state disciplinary records. So they basically said that this is an area where this working group could look at and determine if they wanted to make changes. Just to go over the two areas of discipline really quickly, as a refresher, these are all non-disciplinary outcomes. So these are outcomes that don't go on the website. There are resource letters, there's warning letters, there's directional letters, referrals to lawyer assistance program, and sometimes agreements in lieu of discipline. This is not what we're talking about. This is just other non-disciplinary outcomes. What we're talking about is private reproval, public reproval, probation with state suspension, and probation with actual suspension, and disbarment. And the reason that private reproval is up there is what we talked about previously, is that sometimes private reprovals are public. If the ultimate resolution of the discipline is private, but the notice of disciplinary charges has already been filed, then that private reproval is public. What the working group did is they initially reviewed other states. So the memo had what other states had online. And one of the tasks that they gave staff was to look up, there were 11 states that didn't currently have anything online. And so I went back and looked up those other states, 11, to see what they had done, because they would have taken these stances a little more recently than some of these other states. Two of the bigger states, Florida and Texas, after 10 years, removed the discipline from the website. It was still accessible if you called them, but they removed it from the website itself. Just a quick, on those 11 states, a couple of states still don't have it online. In 2021, Mississippi and South Dakota still didn't have attorney discipline online. One of the other states, Oklahoma, had it, but you had to know the case number. Kentucky only did active suspensions or disbarments. So any other level of discipline wasn't online. The other states kind of decided to go forward. Alabama and Idaho, just from a certain point in time forward, the discipline was online. And then some of the other states that adopted it went back I got to talk to lovely individuals in Louisiana and New Mexico, and they couldn't give me a precise date that it went back to. So that's why you'll see 1940 or 1950s. They think it went back that far, but I didn't get a specific date. So the working group took these other states and how long they kept their discipline on the website into account. And then they also looked at other California agencies. So we specifically narrowed down in our comparison nurses and doctors. And the nursing board in particular had a very, I think, good website where it talked about specifically in an effort to balance the public's right of to be informed about their healthcare practitioner and also the licensee's privacy concerns having fulfilled that discipline. So it has this chart on its website that talks about the level of discipline and how long it would be on the website. So if someone's going to peruse their website for their nurse, they will be able to see that, oh, okay, there are limitations to what is on this website. And I think it makes it very clear through the disclaimer and through the graphic of what is on the website and what is not on the website. So we took this information and we added doctors and attorneys to do the comparison. And so you can see that for attorneys, the discipline currently is all available on the website. At a previous commission meeting, we had public comment in written form, and then the attorney actually came on and provided public comment about his public reproval that happened 12 years ago, and he had to find a job, and he found it very hard to find another job because that public reproval is still on the website, and he felt that it was on the website indefinitely and that he would hope that it would someday come off the website. So the comparisons were made, public reprovals are public indefinitely with the state bar. For doctors, it's 10 years from the effective date. And for nurses, it's 3 years from the effective date. So this is kind of the comparison that the working group took into account to review its website, the attorney website, and if there should be modifications to the website. And so the next slide is the results of all of that discussion. And this is supposed to be a synopsis, and then we turn it over to the different working group members of how they came about these. And again, this is much like the ENEC working group. There wasn't unanimity in this discussion. There was some working group members that thought these amounts of times were not enough. And but this was the majority of people that attended the meeting agreed with these results. And that was private reproval was when conditions were met or 1 year, then it could be removed from the website. You could still call in. It's not expunging the discipline. It's not getting rid of the discipline. It's just the length of time it is on the attorney's profile page. And so it went up from there with 3 years for public reproval, probation with state suspension, 3 years or conclusion of the probation. With actual suspension, it was 5 years from reinstatement. And then disbarment, there was no change made to disbarment. And the thought around that was that the concern for the unlicensed practice of law, that we didn't want to remove those disbarred attorneys for fear that they could try and present themselves as attorneys. And if you remove the disbarment from the website, the public would have no way of knowing that. And so this is where I'm going to take down the slide and turn it over to the working group members to kind of articulate the idea behind changing what is publicly available on the website. So I don't know if I have any volunteers. I know Sarah was on the working group and Michelle and
I'll go ahead and say something. This is Ray Buenaventura. So I think the working group was really concerned with, when an attorney starts practicing law and they develop a career, and if you take maybe a 20-year career in law as an attorney, and your discipline and that affects you for 10 years, you're basically out of commission for 10 years. And so that's half your career. And so I think the idea was, what can we do to be fair and sort of balanced, and looking at the other agencies and the other states and how they were doing it. And I think we came up with a good combination that does address the public's need for, so they can have some confidence in the state bar, but as well as to not be overly punitive and recognize that people do make mistakes, but they still could have a career in front of them, and we shouldn't take a overly harsh position when compared to other states and other jurisdictions. Thank you.
All right, any other members? Okay, I see Ms. Good.
And then to add to Mr. To Ray's point, I think that members of this subgroup were also focused, and at least I was, on remediation in light of the findings of the Farkas report and permitting folks to move forward with their lives and their careers, while also balancing the public interest in assessing some of these things. And that's why there's kind of a sliding scale. We separated out our discussion between what's on the website versus what should be able to be expunged. And ultimately, I know that Ray and myself thought that the two should be coterminous. So it might be more useful to move to the latter discussion, unless anybody feels strongly that whether or not something is on the website should be different than what ultimately is permitted to be expunged or not.
I mean, that approach makes sense. Anybody have any strong objections? Okay, Steve Moad.
Thank you. I certainly don't have a strong objection to the procedural part of moving on to the second part of the discussion. I did just want to point out that I was the outlier to which Justin referred as far as thinking that this was all a good idea or would benefit both the respondent and the bar. I do think that, as I pointed out to the subcommittee or working group or whatever it was we were a part of, one of the main criticisms about the bar that we hear frequently, in addition to the 180-day timing, which was discussed in the earlier discussion, is that the bar does not discipline attorneys sufficiently. And so I think that while we do need to find the right balance between the discipline and allowing people to get on with their lives, I think it's an important consideration to look at both sides. I also think that that some of our stakeholders may have some concerns about even with the disclaimer being on the website saying, hey, some of these things, some other things may have occurred here, but we're not going to show them to you here. You would have to call us for that information. May not be seen by some of our stakeholders as appropriate. And that may be problematic for other reasons. I think that the website was not listed in the statute saying that it had to be listed there because that statute was adopted, I presume, well before the internet, and that it was required that people would call in, so on and so forth. It's not that the legislature doesn't have the ability to amend the statute. In fact, I think they amended that statute last year for this year as part of the fee bill, but I don't think they were looking at it with that in mind necessarily. So I think that we're going to have to find the right balance. But with that, I'm happy to move on to the next discussion.
All right, Mr. Larkin.
Thanks. I just, I do echo Steve's point that the public, I mean, the messaging has to be very clear so the public isn't misled about what isn't on the website, and the idea of having to call in to make sure that any information one wants is just not available on the website, but available on call-in. I think that also makes prudent the suggestion Sarah had, kind of look at whether to actually expunge the record, in which case the public could be confident looking on the website that they know what is available. I do have a question though about data, and maybe it's in another slide Justin's going to show us what other states might do in terms of actually expunging a record. It's not something I'm really familiar with, though I understand the Farkas report goals, and I appreciate looking at something new, which for me, actual expungement of a record would be something I'm just not familiar with. So I look forward to the discussion.
Justin, do you want to handle that now or later on?
Yeah, I think it might be useful just to continue, because I bifurcated the discussion again, but I think everybody's saying we should just go through the whole slides and talk about the expungement process. I think that might be useful. Okay. So I'm
and let me just real quick here, Ms. Rosenblatt, anything to add to that, or are you okay moving on?
Just as a point of discussion, I would want to bring up, I think, an aspect that has not been addressed, and that is the ability of a family law attorney like myself to consult the state bar record, which I do regularly when I'm dealing with opposing counsel. I would disagree respectfully with Ray Benaventura that when attorneys get disciplined, their careers are on hold. That's not true, at least in Santa Clara County and Alameda County and San Mateo County, because a number of attorneys I've dealt with do have a disciplinary record. And I would like to point out the kinds of discipline that have been actually substantively necessary for me to press my client's case, given the history of attorneys that this client, my present client, has had. So I just want to stay tuned.
Okay. Well, with that, we will stay tuned. We're going to break now for lunch, and then we'll open back up with Justin getting into the rest of his presentation. All right. So we'll see you guys back here 12:30.
Okay, we are recording again.
All right, so Justin, do you want to go ahead and then continue on with your presentation?
Sure. Let me share my screen again. Hopefully, can you see my screen? Okay. So in terms of expungement, talking about expungement of discipline at the state bar, these were the key questions that the working group had to determine. What does expungement mean? There are various levels of expungement. Does it mean that they can say to their client that they weren't disciplined? Do they still have to disclose this to the Ginny Commission? What does the expungement mean? And then they looked at the levels of discipline. What should be eligible for expungement? As was stated earlier in the meeting, murder isn't eligible for expungement. But so they had to look at the levels of discipline to determine what is eligible for expungement. And then the third question was, should the process be automatic or based on petition? And they talked about in the criminal justice system, the criminal courts, how there's a recent move to make that expungement automatic. So whether or not that would apply to us or not. And then the final one was, how much time should pass before someone is eligible for expungement? And Sarah kind of previewed it that these recommendations and the recommendations for removal of the website ultimately kind of coalesced around the same amounts of time. Another thing that the committee looked at was the administrative expungement, because that's the only expungement that is really used at the bar currently. And in terms of administrative expungement, there are two types of things that administratively can be expunged from an attorney's record. One is for a failure to pay licensing fees, and the other is for a failure to do your minimum legal, your education. And so if certain requirements are met in each of these circumstances, a one-time expungement can happen on the attorney profile. And those conditions of eligibility are, the suspension was 90 days or fewer. There hasn't been another time where it was expunged, and either for MCLE or lack of failure to pay, there's no other record. So no other involuntary inactive enrollment or anything. And these records are expunged in the way that they come off the attorney's profile, but for the Commission on Judicial Nominees and Evaluations, these will still be provided to that commission. So that's what expungement means in this context. The California Supreme Court is the one that can expunge the record for a lack of failure to pay fees. The Supreme Court has delegated to the Board of Trustees the MCLE expungement. And so the Board of Trustees can expunge one time for both of these things. And the reason I bring this up is it was discussed in the working group itself at whether or not they wanted to expand these expungements. And maybe it's 120 days or any types of change to the expungements. And the working group thought that these expungements were fine as they were, that no changes to the administrative expungement were necessary. So then we looked at criminal expungement in the state of California as something to kind of base, since there isn't really an expungement process now. The working group reviewed several aspects of the criminal expungement, and they talked about Penal Code 1203.4, conviction expungement. They talked about all the different ways in which one is eligible and how that may translate over to the state bar. The Penal Code 1203.4 allows a defendant to withdraw a plea of guilty or enter a plea of not guilty if they've been convicted of a plea of not guilty. The court shall set aside the verdict. And these are useful in applying for housing or employment or education, scholarship. There are a bunch of exceptions, and this is why we looked at the criminal context on what should be eligible expungement and what does expungement mean. And some of these exceptions for this are, peace officer application or firearms permits or, different licensing agencies. You still need to disclose the offenses to these individuals. Now, like I said, most private background checks won't find it, but if you are applying for these specific things, you still have to disclose this. Another thing that was considered when we reviewed this is AB 1076, which is the Clean Slate Act, and it was originally going to go from 2001 forward, but then they passed AB 145 to extend it all the way back, which was in the original bill, but got pulled to 1973. And so this is just kind of giving context that they are doing this automatic expungement of records now. And the idea behind this is that people don't always pursue this. They don't have the means to pursue this. And so this is a trend in the criminal system. Whether or not it translates to the state bar or not is, for the working group and the commission and the Board of Trustees to decide. But these are the types of topics that were discussed with the working group. Another area is that I think Jerry talked about is other states. And there wasn't a lot of expungement and discipline in other states. A lot of the expungement, when we got the responses for other states, were basically the closed complaints. When we talked about closed complaints, that's what they considered expungement, was closed complaints with no discipline. They expunged those. I think Illinois, it's like 3 years and it never happened. It's totally gone. Some of the other states that. These were some, if you call them like private reprovals or admissions or something that we could consider expungement. I mean, in Pennsylvania, informal admissions 4 years or older or private reprimands 6 years or older would not be used in subsequent disciplines. So it's technically expunged. It's still on the record, but they wouldn't be used in other discipline. But there wasn't a good case study, if you will, for what we are considering or what the working group is considering here. And currently it's Business and Professions Code 6092.5 states the state bar shall expunge the records as directed by the California Supreme Court. So this allows an attorney currently to petition the Supreme Court to expunge the record. We could find 2 instances where this occurred, both were denied, and it's not a well-used avenue for attorneys to get their records expunged. So that was kind of a brief, we had multiple meetings, but that's a brief summary of what we looked at when the working group was deciding on what to expunge. And so when we come back to those questions of what does expungement mean, the working group said that it is non-disclosable to the public. So that's what expungement means, is that it's not something that they would have to publicly disclose anymore if it was granted. It would still be disclosable to the Commission on Judicial Nominees Evaluation, and it still can be used by OCTC in subsequent discipline. So there is still a record, but it's not publicly disclosable, is where the working group kind of coalesced around thinking for this question. The next question, and we'll have the working group kind of discuss later on what they were thinking when they came up with these decisions. But the next question of what should be eligible, and again, it came down to all of the levels of discipline below disbarment, the idea that disbarment and the unlicensed practice of law was still a consideration, plus it's the highest level, and there's an avenue to be reinstated through disbarment after 5 years. So the decision was all levels of discipline but disbarment. And then talking about whether it should be automatic or petition-based, where with a petition there would be some discretion, the working group came to a decision that the low level of discipline, the public and the private approvals, would be automatic. So if there's certain conditions were met, we didn't get all the way into the weeds of defining those conditions, but if certain conditions were met, then it would automatically be expunged. And then for the actual probation, whether they have a state suspension or actual suspension, those would be petition based. So you would have to go through the process and petition, and whether or not it would be granted. Again, the certain specific requirements for being eligible were not in detail, but this was what the working group was thinking. And so that brings it back to how long before someone is eligible for expungement. And if this slide looks familiar, it's because it is. It's exactly the same as what was the expungement for on the website, that someone would be, the first 2, private approval and public approval, would be in the automatic category, and then the probations would be on the, you would have to petition for those. So that is kind of a brief overview of what the expungement working group looked like. The recommendations for expunging from the website and expunging of the discipline record to not disclose ultimately became the same. And again, it wasn't unanimous on the working group, but the working group was, talked about, as we mentioned before, addressing the Farkas reports and the disparities it found. So that's my brief overview of what the working group did. I will now turn it back over to the working group to kind of explain where they came from.
All right, who from the working group would like to go first?
I don't know, Raison or Sarah or...
I thought Mr. Moab would want to go first, but.
Oh, okay. I'm happy to go first. I as may not come as a shock to those of you who have been paying attention. I was the lone, apparently unreasonable one who kind of was not in favor of the recommendations as posted, which is why I thought that maybe somebody else would go first. But I think that again, as having spent a significant portion of my career in consumer protection, including my time at the state bar, and my prior life as a deputy district attorney in the consumer protection unit, I have a little bit of a problem with this concept, particularly with the timeframes of essentially concealing this information from the public, which I think is potentially problematic. I think that the working group decided, and I think appropriately so, that OCTC can still use these disciplines in subsequent discipline, and I think that's appropriate. I think that the working group also decided, which I also think is appropriate, that the Jenny Commission can use it to evaluate people. But I did point out to them, and I will point out now, that I think that if it's appropriate for the Jenny Commission to use it to evaluate people for the bench, why would we not want to allow the public to use that to evaluate somebody that they're looking to hire? I understand that people have to have an opportunity to move on from the discipline, but if, for example, a member of the public is evaluated and hiring an attorney, and there is nothing, not only not available on the website, but even if they call in and say, hey, is there anything else there that I should know about? And the bar says no, and then they go hire somebody, and then they find out after having this attorney commit misconduct against them, they find out that there was prior discipline. I think that just leads to an unjust solution. And I think it's problematic. I also think, for example, when you look at actual suspension, the actual suspension standard is 5 years that we settled on as a group. That actual suspension could be 2 years long, right? Which means in a mere 3 years from then, that record could be removed from their record. Somebody has to do something pretty serious to be suspended for 2 years. And I'm not sure that is an adequate amount of time. It seems like we would be alone in removing that, aside from, there's, I forget, Kentucky maybe, who says that if it's not an active suspension, it's not on the website. I don't recall, Justin, whether that means that the public couldn't get the information at all. If they called in, for example. But most of the things of the states that remove that information, I think is just the website. And even then it's 10 years. And so I don't think that the amounts of time, even if we're going to go down this road, which I see as potentially problematic, is appropriate with that time frame. So those are my thoughts. I'm happy to answer any questions or have everyone else on the committee state their position.
All right, I'll first ask, does anybody have any questions for Mr. Moad? And if not, then I will, I just saw Jenna Jones had her hand raised. Okay, Jenna Jones.
Thank you. I don't have any questions. I just wanted to echo Mr. Moad's comments. I think the timeframes that are being suggested are a bit short in light of public protection. I think additional time would be warranted, but I'm certainly open to discussion. Thank you.
All right, I think Ms. Rosenblatt was next.
Thank you. Again, my question is a threshold question. When you consider the suspensions, particularly because that's where I have been helped by the bar record in dealing with 2 clients, and the substance of those, the reasons for the suspensions were material and important for the resolution of my post-judgment cases. So I have some reservation. Well, number one, about the nature of the type of the reason for the suspension in the first place. And again, its relation to how clients, the public is compromised or their legal rights inhibited or prevented because of this attorney's behavior. So the relationship of that original behavior to the suspension, but then given statutes of limitations in family law, and the question of statutes of limitation, what is the reasonable time, given the kinds of cases that this attorney continues to, where this attorney with a previous discipline problem continues to represent clients, these attorneys do not go out of business. They stay in business. This is my, regular observation. So I'm just questioning about the nature of the suspension and the relationship to the expungement. I think this timeline, my instinct is that timeline is too short.
Okay. I think Mr. Sleg was next.
Thanks. Thanks, Brandon. Justin, could you put up the chart with the proposed time limits again? Just help me. Because I will join the course that I'm supportive of this concept, but I think the time frames are too short. So I would be inclined to change public approval to 5 years, probation with stayed suspension. Not sure about that. Probation with actual suspension, I think at least 10 years. But I think we may also want to, with actual, misconduct has to be pretty serious to warrant an actual suspension. So I was that's one. I may want to differentiate among actual suspensions between, say, a suspension of a year or less a year and more than 1 year, because Steve's absolutely right. 2 actual suspensions, very, very serious conduct. And we may want to exclude some of those or have a longer period where not ineligible for expunge. And I missed this, but I think that expunge should only be available if there was no further discipline with that time frame, right? Because the whole concept of this is, if you have been on the narrow for 10 years, I think we can have reasonable certainty that you're going to be a recidivist, right? But if you kept offending during the period, then I don't see why we would take down that information from the website. So that's a kind of a nuance that I think we need to consider. And the final thing I'd throw out is, I've always thought it's crazy that a private reproval imposed after the public filing of charges in state bar court is actually public. And so you keep hearing people talk about a private and a public. I mean, it's like out of 1984. It's nuts. So I think it's just an anomaly. It's not I don't think it was really a policy decision. I think it's just kind of an anomaly that stems from the practical reality that the discipline case is public, right? Because the charges were filed publicly. The court file is open to the public. But I don't think that's a good policy reason for posting a private reproval on the website. If the court determines it's a private reproval, then I don't think we should post it at all. So that's my 5 cents on all of this.
I'm not sure who is next, but anybody wish to address Sean's comments? Or just further questions and comments?
I wanted to address just one comment.
Yes, Ms. Good.
Which might be helpful, which is, Mr. Seleg, it was always contemplated that there would be no other offenses to be entitled to expungement. So just to make that crystal clear, that's what we contemplated.
I have a quick comment for Sean about the anomaly of the private and the public. I'm the one that lost that case with the Cal Supremes. And the rationale of the court generally was this, that once a notice of disciplinary charges is filed and there's a private reproval that is the ultimate resolution, then hypothetically, theoretically, before the internet, one could go down to the state bar court file and find that private reproval, so that it was then a public-private reproval. And the corollary was that when the internet kicked in and there was a website, that essentially what the website was doing was facilitating the old school process of going down to the courthouse and looking at the actual file. So that's the rationale. I didn't agree with it then. I don't agree with it now. But to me, a private should be private. But that's the history behind it.
Okay. Brandon, can I just respond to that one point? It's just very focused. So that's great history, Ed. Thank you so much. Yeah, I think it's recognized now that public records don't always have to be on the internet, and it's a different policy decision between, the old school way of going to the courthouse and looking at the file versus posting everything on the internet. So, for example, some family law cases are not available on the court's public websites. So there are certain policy choices the courts have made to limit internet access to otherwise public files. So it's worth a relook.
Right. I'm going to go in order that I think there is her hand. Janet King. Oh, Janet, can you hear us? All right, we'll move on to Michelle Anderson.
Hi, I just was in agreement with Steve on most of what he said, but I believe that probation with actual suspension should be a longer term. I just think 5 years is too short a period of time. Perhaps maybe 10 years would be more appropriate on that situation, because I think that the whole purpose, I too come from a consumer protection background. And I think that with actual suspensions, I think that the public needs to have that additional information. And I also believe that in the expungement process that with stayed and actual suspensions, they should have to petition for it for the purposes of making sure and having a checks and balance that they have complied with all of the terms and conditions of their suspension or disciplinary action.
All right, thank you, Ms. Anderson. Judge Gill.
Thank you. So let me just give you some other, maybe it's more anecdotal information, but I think things you have to kind of consider. In response to the point about 2 years suspension, I think that Sean mentioned a little while ago, in relation to that slide again. Justin, if you could put that slide back up, I think it's kind of helpful to see it. So when according to our disciplinary standards, when there is a 2-year suspension, it's not really just 2 years, it's 2 years and until. They have to something that's called a mini reinstatement that those at that level of suspension have to get. Now the standards of proof are lower there. It doesn't happen that often we get these mini reinstatements, but it is an issue where 2 years is usually something longer than 2 years. And to the other point about, discipline that's actual suspension is really serious stuff, I would have exercised some caution with that. I want to give you one example of one particular area where I think sometimes the discipline and the effect of it is a little bit more than what people realize. So in looking at MCLE requirements, we get a number of cases where people have not intentionally, but with gross negligence. So they were a little reckless in signing their affidavits regarding MCLE. And in particular, there's a case called In the Matter of Ye, which was decided about 6-7 years ago, which imposed a public approval on somebody who, due to her failure to keep accurate records, signed the affidavit that said that she completed her MCLE requirements when later, when she was audited, she could not prove that. So in that circumstance, we had somebody who wasn't intentionally, the court ultimately concluded that there was no intentionality on her part and that she just basically kept sloppy records. And that resulted in a public approval. So I'm kind of wondering, as someone in her situation, is 3 years sufficient? It could be. But then again, people who are with some MCLE cases, we have seen people winding up with 30 days, which is an actual suspension. And so I guess my main point here is that sometimes low-level actual suspension is and can be for stuff that's not really intentional. Sometimes it's just oversights. And given the type of case law we have on moral turpitude, where those kind of issues come up, it becomes a little, I think you really should just be very careful about making the assumption that low-level suspensions are what Sean said. I just think some little bit more thought needs to be kept in everyone's mind when you're talking about who actually qualifies for actual suspensions and how they wind up and for what type of acts they really engaged in when they're not intentional. And that does happen in some cases. So I just wanted to offer up that. That's a little bit more nuanced issue. When it comes up to high-end discipline, I kind of agree with what Sean and others have been saying, in that perhaps one way to look at it is that maybe the 5 years should be once that person's actual suspension is completed, and then they basically have 5 years of no disciplinable behavior after that, as opposed to the 10 years, even though the 10 years was good enough, I think, for the medical board, if I understood the previous slide correctly, Justin. So, again, we might want to be looking to what the medical board and, the sort of issues that they looked at and coming up with their decision on what to do. Because, much like wanting to keep abreast of what an attorney does, I think most people want to keep abreast of what their doctors are doing or have done or failed to do. So those are just kind of my general comments.
So Judge McGill, would those be consistent with a viewpoint that you think there should be a petition process in place instead of just an automatic drop-off period?
I don't see any problem necessarily with a petition, but again, that just adds cost. I wonder what sort of cost would be involved for people, because a lot of solos, sometimes that kind of cost issues might dissuade them from trying that, I guess. I don't know. I'm kind of neutral on that one. I didn't really think about that so much, Sean. Brandon, sorry.
Oh, no worries. All right, let's see. I think Mr. Larkin was next.
I find this a fascinating discussion. I favor a petition process in the serious cases because you want to be sure there's not something percolating. The premise of our discussion is that lawyers who are suspended and return to practice, or disciplined and return to practice, that many do. And like Eloise spoke to that eloquently. So I think it's that cuts both ways to both arguments, I think. And there are valid points on each side. It's just not typical across the country, as Justin's data showed, for lawyer regulators to have expungement of the actual record. The only other offering is that in the age of the internet, the bar is going to find itself in a position where someone's going to come to the bar and say, well, you don't show any discipline, but I have the press release from the local paper showing this lawyer was, suspended for egregious conduct. Why don't I know that? So it's more of a practical consideration. We faced a request like this from a lawyer who'd been suspended for about 3 months, and our court keeps the record unexpunged and available on the internet indefinitely. And he took the position that he was losing business. Well, this person happened to be a pretty notorious fellow who tried to get business by showing how unreasonable he continues to be. So really, if you look at it, the discipline was his badge of honor because it involved similar conduct. It cuts both ways, though. If the lawyer has been disciplined, it is a fitness issue. If the discipline is ended, you think fairly that should end. The lawyer is going to be able to practice. It is the courts and the discipline system certification that he's fit. She's fit. So this is a very fascinating question that you're answering, I think, for the first time among national lawyer regulators. So I'm anxious to listen.
And just to kind of put a finer point on Mr. Larkin's comments, as when I first started to read about this, the thought that, once it's on the internet, it's kind of forever. There's no right to, to disappear from the internet, at least now. So as a public protection agency, is it our duty to, post to give the public an accurate view of what discipline has been imposed? But then if there's been substantial steps taken, and then the state bar court in its discretion decides to grant some sort of a relief under expungement or some other means, should the state bar then be that repository for that decision, and to show consumers that there has been this past action, there has been remedial steps taken, and here's the factors and mitigation that the court considered to rehabilitate that individual, almost kind of like a certificate of rehabilitation at the state level. You have a state crime, you can apply to the court for a certificate of rehabilitation, and that then is kind of a further demonstration above and beyond that, just even filing for like a 1203.4 and that expungement, but it's like one step further. So just wondering if there's been any discussion about whether the state bar court, if they make that decision, if the state bar website then could then convey that to the public, if it serves any sort of common issues on both sides of this discussion. Anyway, not to get off topic here. Let's see. I think Ms. Bell was next.
Thank you. I just wanted to say that if the purpose of this whole process is to protect the public, not just to be punitive, then I'm wondering if the data on recidivism has been looked at in terms of whatever these timeframes would be, because it seems like that would be the critical question is, after X number of years, if someone's unlikely to recidivate, then why would we want to continue, poisoning the well and preventing them from being able to get clients by advertising so blatantly and obviously, this discipline that was imposed on them, when for all intents and purposes, we have no reason to believe that they are a continuing danger to the public. So I'm just wondering if the working group looked at that issue at all.
Anybody on the working group wish to respond?
The working group didn't look on the data on recidivism. Another working group did look, the diversion working group had some data on recidivism, but that is an interesting topic. And I think that we could get that data for, a further discussion on this.
Okay. All right. Yeah, certainly something to be included in the next meeting materials. I'm gonna go back to Janet King. Hopefully your technology issues are resolved.
Yes, thank you. I also just wanted to provide public 2 cents. I think the timelines are too short. And I think that, especially comparing to the healthcare practitioners, I think we should at a minimum be equal, if not longer, than those timelines for the state and actual suspensions, as far as in addition to the disbarment. Actually, let me back up. I think that if we're trying to increase the public trust and allowing them to search for an attorney, I think that we need to have easily and readable online searches with full transparency. I think it's just valuable and crucial to let the public make their decisions. If they're already been convicted, it just needs to be spelled out and without monitorization, and people can make the decision. Thank you.
All right, I'm going to go next to Ray Buenaventura.
Thank you. Thank you very much. So although I appreciate the very robust discussion on the public trust and the importance of that, I do think we need to bring this back to why we are even here in the first place. And it was to address the disparate treatment of Black attorneys in the attorney discipline system. So that is the issue that brings us all, I think, together here. And so I think the question that we need to ask ourselves is, so how do we begin to address that? And I think that the idea of an expungement is a starting point because it is something that will change, I think, and remove some of these barriers that have existed because of the disparate treatment that clearly we all see as an issue. And so when it comes to expungement, I think we need to emphasize and understand and not forget that we're just talking about, and I'm talking about the timeline, we're talking about eligibility for expungement, at least when it comes to the more serious actions by the attorney. That's not automatic. And so they're going to be reviewed. There will be, I would imagine, a very detailed process, a very standardized process, a very a roadmap, if you will, on how an expungement will be decided and granted. So we're not talking about, for the most of the, for really all of the serious cases, an automatic thing. We're just saying, look, we will allow you to apply for an expungement after these timelines that have been proposed. No one is saying that it's going to be automatic. And so I think we just need to still remember that it's just giving them a process, an opportunity, if you will, to try to see if they can get their record expunged. And again, I fully embrace the idea of the protection of the public, but what we're supposed to be doing is to address the disparate treatment of Black attorneys. And one effect that we could do to change that issue is to have an expungement process that also very much considers how we can affect that treatment. So that's why I think the proposals we came up with, and I understand we were not all on the working group, but the working group really did vet a lot of these ideas, spent just a huge amount of time and a vigorous debate on these timelines. But I think we all recognize that it's just an at least for the eligibility part and the timeline, we're talking about just giving them a chance to apply. And that's why we came up with what's automatic, what's discretionary, what's by petition and things like that. Thank you.
All right, thank you, Ray, for that perspective. I will go to Ms. Rosenblatt.
Thank you, Mr. Stallings. This may be a question for Mr. Ewart. We have talked about the availability of the internet and the distribution of or the availability of records, or at least the fact that the attorney was disciplined via the internet. However, there's another issue as far as expungement or modification or equalization that I've noted, and that is that, and these have all been in the area of Caucasian American-born attorneys, that there is a difference in the amount of material that gets posted on the internet in relationship to the record of a disciplinary action. So what I note, for example, when I open up the records of one male attorney who was related to a friend, his full record of all of his DUI convictions and pleadings was posted on the net in connection with his case or his profile. In another case, a woman who I could never quite get a hold of what the financial issue was, but it didn't have to do with her clients. However, her full record of of all the pleadings and the briefs was posted on the net. In another case where there was an issue of an attorney I was dealing with, there's just a record that her suspension, which happened 12 years ago, is posted on the net. But if you want to get the information, you can. It's available from the state bar, but you have to petition for it, and I suppose have a rationale. So what I'm wondering is any committee or process available to kind of equalize or because it just seems there's a wildly different effect if if the complete record of the state bar proceedings is posted on the net, and when it's just referred to as, seek the state bar for more information.
Yeah, so I think that, and maybe Melanie or Steve can probably say this more succinctly than I, but with the upgrade of our case management system, some of the records are PDF available on our website. So if you go on the attorney's website, you find all of the records there. But if it's more recent, what it tells you, it redirects you to the state bar site. And so the state bar has two distinct sites. One's the attorney profile page, and I think it's the older stuff has been scanned into that. The newer stuff, it directs you to the state bar court website because it's the record of everything. And then you have to enter in the case number, and you can still get the same information. I don't think there's this distinction about the amount of information available. It's just whether or not you have to go through that additional hoop and go over to the state bar court website.
Well, I just wonder if we were going to be attempting to treat attorneys in a respect. I mean, I would actually support, having a consistent policy for these wide open records. I mean, because they vary so greatly in seriousness. So I'm just wondering, between older and newer system, is there a way, is there any task force or some process entrusted with regularizing the where these records are available? I'm just posing the question. I don't need an answer, but just
okay. Brandon, you're on mute.
And Justin, do you know, has this been explored by any subgroups, the ad hoc commission?
I mean, I attempted to give the presentation, I think it was to the subcommittee. I don't know if it was fairness or effectiveness, on the distinction between the two websites, the attorney profile page and also what is on the state bar court website. And we kind of went over consumer alerts at the same time and just what is on those pages. So I don't know. I think it's just kind of implementation wise, why it's set up that way, why it redirects you to the state bar court website, because I imagine it might be a manpower issue to get all the PDFs and stuff to the actual attorney profile pages. There's a lot of duplication, I think, there. But I don't know. I would turn to someone in OCTC or the state bar who's in the weeds.
Okay. All right. And perhaps we can include more of that, more on that at the next meeting. Let's see, Ms. Good.
Thank you. I also was on this working group, as I mentioned before, and I wanted to follow up on some of Mr. Buenaventura's points. I completely support the time periods that Justin put up. And I also completely support and was interested in OTC's input on this issue as well, and in particular, Mr. Moad's input on the issue. Just to kind of refocus us on the Farkas report, I think what we were struggling with is protection of the public and also remediation to attorneys who experience bias in the disciplinary system. That was the subject of the Farkas report, and how to reconcile the two. I mean, I suppose you could look at a rule that's applicable kind of to the Farkas report period, or some time period before all of these new innovations, hopefully, that this ad hoc commission is going to implement take into effect. But I think we thought it was cleaner to develop, one comprehensive rule that also recognized that people should be given second chances. Their career shouldn't be torpedoed by one error of judgment, one mistake, particularly if they then went on to not have any other discipline against them and turn things around for themselves. Kind of the same way in the criminal system, right? That's why we have a criminal system of expungement as well, so that people can get on with their lives and continue to pursue their livelihood. Notwithstanding what some have said, I think any attorney with public discipline would have an extremely difficult time trying to get a job in big law or even a medium-sized firm or even a small firm. I can't imagine that a DA's office or the AG's office would want to hire somebody with a disciplinary record either. So those attorneys, I think, are limited to other choices, solo firms, smaller firms, that kind of thing. I think it does have a real effect on people's career choices and what they have available to them. And so, it is kind of a line drawing here, right? Protection of the public, remediation under the Farkas report. Where do we go? What I keep kind of thinking to myself is, if the greater public looks at what we're doing here and the recommendations that we're making in response to the Farkas report, are they going to think that 10 years is too long and is kind of a mocking response to the Farkas report that presented very serious considerations and allegations that need to be remediated? So that's kind of what motivates me here. And I think one of the reasons why we implemented this sort of automatic versus discretionary is we contemplated that the state bar court would be deciding these petitions. And I can't imagine that they're going to want to be overrun with petitions on everything. We thought there are certain categories of things that are best made automatic and don't come before the court, where the court has to exercise discretion. Again, kind of mirroring kind of the criminal system. And then I was also going to say analogies to other licensures, analogies to other states. They don't really work here because no other state bars had the Farkas report and those findings. So, we're kind of being innovative and crafting a new path forward here. And I think we shouldn't be held back by the fact that other states aren't reacting to this sort of set of circumstances that we find before ourselves. And also, we can all think of horrible anecdotes, I'm sure, that would weigh in favor or against some of these proposals in terms of time period. But all that we can do is try to balance the competing interests and figure out what would be fair. What's fair to those attorneys who may have been improperly disciplined before, and what's fair on a going forward basis in terms of our profession. Is it one strike and you're out? Or do we try to offer kind of second chances to people? That's kind of it for me, but I wanted to give a little bit of context and that I fully support the time periods that we have in place, for those reasons. Thanks.
All right, thank you. Ms. Joseph.
Thank you. I just wanted to say that I was also on the working group and echo everything that Ms. Good and Mr. Buenaventura have said. And I think it's interesting just listening to the first presentation this morning on ENECs and some of those cases that are being looked at where the convictions have been expunged. And when those convictions are expunged, it's not just a sign off by the judge. I mean, there's a lot of different factors that are taken into consideration for 1203.4 expungements. And if a conviction that has, if a judge has made a decision that a 1203.4 should be granted, it's because the court has considered a lot of background. And so I think it's in that similar vein that we're bringing these timelines and these, the issue of expungement and the option for expungement up is not that it would just automatically happen, but that one could apply and that the same considerations that were given in a criminal context would be given here. And especially with the overlap, if we're talking about, the fingerprints being done in 2018 and those cases going up because the fingerprints divulged some conviction that was, not evident before the fingerprints, and that individual had gone through the process, which is a pretty complicated process of before the courts of 1203.4, that if the court in a criminal context thought that the conviction should be expunged, then why would we have a different set of circumstances that we're looking at in this scenario as well? And just to drive home the point again that, the convening of this commission was targeted at figuring out how to reconcile the disparate treatment and the disparate ways of discipline that is imposed on African-American men. And this is a way to try to address that disparate treatment. And I don't think that we should lose focus on that when we are talking about timelines and when we are talking about protecting, the public. I think that is always at the center of the state bar, and OTC is protection of the public. However, the report has uncovered what is, in my opinion, some very stark realities of how discipline is imposed and upon whom. And if we don't make options or avenues available for people to be able to reconcile that after, completing good behavior or staying out of trouble or not incurring other disciplinary infractions, then I think we're really just keeping the data that we have from the Farkas report as is and not addressing anything that is at the heart of what this commission was convened for. Thank you.
All right, thank you. Any other comments or questions? All right, I don't see any. So I do have a question kind of similar to my comment earlier. Was there discussion in the working group on, just with the proliferation of the internet, with, there perhaps being information outside of the state bar, such as independent news sources, reviews on Yelp, Google, individuals basically writing about their negative experiences with lawyers, or references to, let's say an individual has been prosecuted by the state bar, and that news source is outside of the state bar's control. Was there any comments about or discussion about ways to remediate that sort of news that's now out there in the internet? And as far as people referring back to the state bar website and then using that state bar website as really that official record, and whether or not we should have, I guess, more information as opposed to less information. If an individual has taken steps to go through the expungement process or show mitigation that the court has now taken into account in granting an expungement. I mean, has there been any thought on how the state bar can further, I guess, clearing someone's name or showing that they have in fact been rehabilitated?
So in the working group, Brandon, I think we touched on that issue a little bit in just the terms of when we looked at the nursing board and their disclaimer. And I think the discussion was about how the state bar would have to be very clear on what it was disclosing. We talked in purposes of the website, or the whole process. So if we do develop this expungement process, we have to be very clear on what we are able to disclose. And that was very important to the working group. I don't think we got into in-depth discussions about other sources, because obviously if it's on the internet, people take snapshots of the internet every day. So you can go back, and find something. So it's never truly expunged. But I think where we touched on that conversation was that whatever the decision is, it has to be explicitly clear and easy for the public to determine what is publicly available and what isn't publicly available.
All right, so in regards to ultimately this commission voting up or down a proposal, kind of broken it down into a couple different things. One, whether there should be a expungement process. And so I think that to that threshold question, can we get kind of just a general sense from the members?
Well,
So if you, oh, yeah, go for it, Justin.
So what I'm hearing, and people can correct me, there seems to be two camps for this, and one for like the original recommendations and one for more time, let's just say. So there seems to be a kind of a coalition between the two camps. So what I think would make sense, and there has been a data request on recidivism, which I think is good and should be brought back in terms of determining the amount of time something's on the website. But if I can just kind of either get a volunteer from each of the camps to work with on, because it's very hard to write, and not violate Bagley-Keene in a group setting. So if I can get a representative from each camp to work on this and, and come back with the recommendations, because I think that ultimately both sides putting it into writing as to why they feel the way they feel with that information on recidivism, I think is how we can move forward, or it makes sense to me to move forward. I haven't heard any distinction between what's on the website and what is expungement. We the original working group said that they should be the same thing. I haven't heard really much deviation from that here. But if that is something that some people think that there should be differences between what's on the website and what is actually expunged, that would be something that I would also want to know now, because we need to include that in the report. If that's not the case, then I think if we have representatives from each of the kind of two sides, I think I can work on getting a write-up and then ultimately having the commission vote which way they prefer at the next meeting with that additional information.
All right, does anybody wish to address Justin's point about the distinction and what's being expunged? Any concerns? Okay, Ms. Good.
I just think the two should be the same. I don't think there should be a difference. Whatever is expunged should be disclosed on the website. There shouldn't be a difference.
Okay, Mr. Moad.
I actually agree, maybe for different reasons. I don't think that something that is not expunged should not appear on the website. So it's a different way of saying the same thing. If we agree that it's expunged, then I suppose if we agree on that, then it should be not on the website. I agree. It should also, we should not have it not expunged, but in some sort of hidden super secret area, right? That to me is not transparent. So in that way, I think it makes sense to have them be the same, although we may disagree about the timelines for expungement. But
Ms. Rosenblatt. Oh, you're still muted.
Thank you. I just want to go back to that, and so that I'm clear about our original starting place. I have no problems expunging and having no record of someone after a certain amount of time who fulfilled their MCLEs and who paid their dues. I have no question about that disappearing. My issue is suspensions from practice, and for what reason? Because I think that I represent the camp that needs to have a longer time frame for taking that information off the, well, I think that these records should be maintained and people should have, and the public should have access to information simply because of the impact of in my experience, of the effect on one's practice, which is an issue we have not talked about. Is we are concerned about freeing persons from a record, a past record of suspensions or being put on probation. But my concern also concerns myself as an attorney in trying to represent my client when this attorney has been has represented my client previously. This has been a factor in 3 of my post-judgment cases. And if I did not know that the attorney had a record of probation and either probation without suspension or probation with suspension, I would not have been able to effectively represent my client and get her money from her dissolution settlement. So, yeah, I think I made the point.
Okay, all right, thank you. Ms. Buffington.
Yes, good afternoon. I'm sorry I'm not able to participate as much as I would like to participate today, but we're talking about expungement. Have we come up with how expungement would look like as far as the process?
So I think that's still on the table as far as whether it be automatic after a certain period or whether it be a petition process. So I think that is probably going to be contained in the differing proposals. So Justin, so I guess Ms. Buffington, does that answer your question? Or
yes, it answers it. I know for the fairness subcommittee, there was a breakout group that was discussing exactly how the expungement process would look like. So, but that was last year. So has any progress been made? Is there like a sample and I know Mr. Buenaventura and I believe Ms. Good, we're researching as far as criminal context, how expungement is like or how it operates, and if possibly we can use some of those policies, rules, procedures to implement something for the state bar. But I'm just, because it seems like we're kind of just talking about expungement in a vacuum, and we don't have like a concrete set of policies or procedures or how we want it to look like. So that's why I'm asking, but that's it.
Justin, do you have any information on that, or is it basically whatever this body wants to come up with either?
Yeah, Shanae, we did discuss a lot of the things in the criminal context and like the eligibility criteria. I think we are kind of high level trying to decide whether or not we want to go forward with an expungement process. And then if we do get that and the timelines, then there's going to be follow-up with the specific things that are going to be eligible. You like we've mentioned before, you can't have any other discipline ongoing or in any discipline in the time where you would be eligible for expungement, and that it still would be disclosable to the commission. So I think those more details, the discussion was had at the working group, but I don't think we have come to this group to decide on those specific details yet until we get kind of a time frame on what we're looking at and agree that this is something that we want to put forward, if that answers your question.
Thank you, Mr. Urick. Yes, thank you.
All right. Any other questions? Okay, so Justin, back to your point. I think we need volunteers from kind of both camps to take this on. Do I have, I guess for lack of a better term, a volunteer from Steve's? Would Steve be a camp? The camp?
I nominate Steve versus Sarah.
I would be honored to work with Sarah and Justin again if they would have me.
Could be too, but it's not a versus situation.
That's right. Sarah plus Steve. Sarah plus Steve equals a hopefully a good solution to this issue. So, all right. So you'll work with staff, and then we'll hear back from you all at the next meeting. Justin, any other direction you need on this?
No, I think I have it. I think I have my direction and the additional information that would be useful. So Lisa is on here too, so we'll be talking.
Okay. All right. Let's see. Justin, you want to take up closed complaints working group now?
Yes. So closed complaints working group. I have other presenters besides me, so you will get someone else on here and don't have to just listen to me drone on. I will provide the brief overview, and then I'm going to turn it over to our Chief Trial Counsel, George Cardona, and then also Lisa Chavez has some information on the closed complaints. And when we're looking at the closed complaints with no discipline, to talk about this, I guess I can start sharing my screen. All right. We're looking at under what circumstances should the State Bar notify an attorney of a closed complaint with no discipline. We had some information on other states and what they do, because right now the State Bar gets, 15,000 complaints a year. And so we don't notify all attorneys that they have a closed complaints with no discipline. But the thought about looking at this issue is there a way we can be proactive with this issue? And it kind of addresses something in the Farkas report, to proactively reach out to attorneys and identify them before they get into trouble. And so that's what this working group is supposed to look like. We've talked about the Farkas report, and I kind of feel like I should have started with the Farkas report, but now I have a couple things that we've previously presented on the Farkas report. We've talked about it, but it evaluated whether there are disparities in the discipline system. The time period it looked at was 1990 to 2009. It explored various different things in the discipline system. And some of the findings that we have talked about, we were already talking about this in the discussion, but without controlling for any other factors, there's disproportionate discipline against Black male attorneys. And they were 3 times as more likely to be placed on probation and 4 times as likely to be disbarred as compared to their white counterparts. And so where this comes into this discussion about the closed complaints is that the study showed that the number of complaints was a predictor of discipline. And so this was one of the findings out of the study, that almost half of the Black male attorneys had at least 1 complaint filed and 12% had 10 or more complaints. So this is where we're looking at, is there something in those complaints? Is there a pattern? Is the type of complaint, is the discipline type of the complaint something that we can identify to proactively reach out to these attorneys and maybe ward off discipline or give them a course correction? So after the Farkas report, the bar asked Professor Robertson to come up with recommendations. And so Professor Robertson came up with specific recommendations for the complaints. And he came up with 3 potential recommendations. One was to expunge the closed complaints without discipline after 5 years. That was not adopted by the Board of Trustees. The second recommendation was to archive all closed complaints without discipline. That was an immediate archival. What the Board of Trustees adopted was to archive all complaints after 5 years. So once there hadn't been any discipline, if the complaint closed without discipline was over 5 years old, it was archived. And I think there was something in the neighborhood of several 100,000. I think someone's not on mute, and I don't know.
And basically, since I first application.
Hey, to members of the commission, if you're not muted, can you just check your status real quick?
I think I muted them. So that was the second potential reform. And then the third is develop proactive non-disciplinary system to support attorneys at higher risk of future complaints. And we are doing some self-assessment. You could even say that this is trying to find a proactive way to do this. And so this is kind of some history background on the closed complaint issue. And since OCTC currently has archives these complaints and still grants access to the complaints under certain circumstances, I thought it would be useful to have a presentation from OCTC as to what they use the complaints for, how they get access to them, and then once they do have access to them, or even prior to the 5 years, what they're looking at in these complaints, and maybe the working group can identify things that, okay, if it's this number of complaints, we should notify them. I don't know what the tipping point would be or what it would be, but it's for discussion for the commission. So right now, I would like to turn it over to George Cardona, our chief trial counsel, to kind of walk us through how one would get access to the complaints and what they're used for, the closed complaints.
Sure, so I'll try and share my screen and hopefully this will work. So hopefully everybody can see that. So basically, in July of 2020, the board put in place a resolution, which basically directed us to implement an interim reform that closed complaints more than 5 years old should not ordinarily be considered in evaluating and investigating a new complaint, with exceptions permitted based on a written showing to an attorney at a very high level in the office, either an assistant chief trial counsel or higher. And also made clear that for this purpose, prior closed complaints don't include those resolved with certain things short of full discipline, such as a warning letter, a directional letter, a resource letter, or some agreement in lieu of discipline. So it's truly complaints that have been closed without taking any of those actions. So this was implemented in November 13th of 2020, after some steps were taken to make sure that our case management system could do it. So under our policies that are now in place, complaints closed without discipline, warning letters, directional letters, resource letters, or agreements in lieu of discipline are archived in our case management system after 5 years have elapsed from the case origin date, or in the event that it is closed and then goes up through review and is ordered reopened from the case reopened date. There's an exception if the attorney has been disbarred or resigned because they're no longer there. There's also an exception if an attorney has another pending case, an investigation, pre-filing, or state bar case, in which case closed cases aren't archived until that pending case is closed. And in terms of getting access under our policies, OCT staff simply don't have access to these archived complaints except under limited circumstances. And in particular, if someone wants to get access to it for purposes of evaluating, investigating, or prosecuting another complaint, it requires written authorization from an ACTC or higher based on a written showing to that person, and can only be granted for these very limited circumstances. When we receive a communication relating to an archived complaint and we need to go back and look at it to determine whether it should remain closed or whether additional proceedings should be initiated, or when the existence of an archived complaint is relevant for something that would become relevant under Evidence Code Section 1101B, for example, to prove up knowledge, intent, plan, identity, something along those lines, or to rebut evidence that the respondent tries to put in. So these are the very limited circumstances under which access can be granted. And again, it does require a written showing explaining why access is needed, and that has to be approved by an assistant chief trial counsel or higher within the office. So in accordance with the resolution. So that's basically it. Justin, I'll stop sharing.
Thanks, George. And now Lisa has some information on the types of closed complaints. You're on mute, Lisa.
Good afternoon, everyone. I'm going to share my screen at the moment. I'm going to share some research that my office did as a result of a request from the working group that asked us specifically to look at, of all attorneys who were disciplined, tell us what their complaint history looked like. And in particular, the group asked whether or not specifically to compare complaint history to what people were disciplined for and how that compares to what they were previous complaints were filed for. In other words, the categories of allegations compared to the allegations of convicted offenses. Before I start, I'd like to acknowledge the work of Jason Dubois, who's a program analyst in Araya. One of the best parts of my job is that I've been able to really build up a very robust team that has been able to respond to the kind of rich and varied requests that the original research in the process. So thank you, Jason. Let's go ahead and start.
Ms. Chavez, I'm sorry. This is Shanae Buffington. Can you speak up? I can't really hear you for some reason. I'm sorry.
How about now?
It's better.
Okay, thank you. I'll speak up. Okay. So these were our guiding research questions. We asked, among all attorneys who were disciplined, what share were the subject of at least one complaint that was closed without discipline in their complaint history? And in particular, we looked at what misconduct is most likely to be disciplined and the subject of complaints that were closed without discipline. Our analysis was confined to 273 respondents who received their first discipline between these 2 years, 2018 and 2020. They were disciplined for an original matter. That means that they were disciplined for a matter that came about a result of a complaining witness filing a complaint. And again, for each of these 373 respondents, we analyzed their complaint history. So let me give you an example of how we analyze their complaint history. Here's an example of someone who, just skip all the way to the bottom, that they were disciplined in the form of reproval on September 3rd, 2020. All the rows above are all their complaints that we have in our database. And we methodically went through and compared, we calculated two data points here. One is we looked at, of all the previous complaints, let's look at the days closed between their different closed cases. So case ID shows that this person actually had 11 separate incidences of cases. That means that it was a closed case. So each row is one case. And we calculated the days between each closed case. And then we also calculated the days from each case that was closed to the case, the date that the discipline was imposed. So at the bottom then, for every single 373 people that we analyzed, we were able to understand the number of prior closed complaints. So in this case, this person had 11 prior closed complaints. On average, there was 182 days in between these different the past closed complaints. And then this value here at the bottom shows that the earliest complaint that this person received came to the attention of the state bar was around 5.5 years. So if you look at when they're eventually disciplined, their first complaint that came in was 5.5 years. Okay, so here's some preliminary results. So this chart on the right shows the number of prior closed complaints. And so let's start with the bar at the top. This shows that 9% of the respondents that we analyzed had 0 complaints prior to their first discipline. 40% who were disciplined had between 1 and 5 closed complaints that were closed without discipline. Going down to the bottom, we grouped together people who had more than 10, and as you can see, 28% had more than 10 closed complaints in their complaint history. This chart here looks at the elapsed time in between these closed cases and then the time from their first closed case. And the results are pretty intuitive as what you would expect. Let's start here with the bars on. So the blue bars represent the median years since the first closed complaint, and the red bars are the median years between cases. And so let's start with the folks that only had 2 prior complaints. They received a complaint roughly every 5 years over a 10-year period. Whereas you I think about the people who had 21 or more prior complaints, they received a complaint roughly every 6 months over a 16-year period. So, so like I said, this is kind of intuitive. The more complaints you have, it was over a longer period of time, and that those complaints tend to come, at a regular basis. This chart shows whether or not the number of complaints that were previously closed varies at all compared to the type of discipline that people received. And as you can see, there isn't a lot of variation here. Again, at the top, this is people who were disbarred or they resigned with their charges pending. The middle bar is the middle visual is the people who received a probation, and the bottom is people receiving approvals. It looks as though the people who have like the really high number of prior complaints, those are among the people with probation, because at the bottom bar here is the number of prior complaints. Each dot represents a respondent. And as you can see, for the most part, this kind of reflects that, you know, regardless of discipline received, most people are having, you know, fewer than 10 close complaints. Okay, so next we looked at specifically what people are being convicted of and how that compares to what close complaints were addressing. So I think as I've shared before, whenever we've done an analysis of complaints, State Bar has over 400 offense categories, and we recently completed a project where we worked closely with OCTC attorneys to take those 400 plus allegation codes, offense codes, and come up with some categories so that we can do some analyses. And so one typology we came up with is 25 categories, and these are them right here. I have an Excel spreadsheet ready to go, so if you have any specific questions of like any of these categories and what those offenses are, I can share that with you. But these are the 25 categories that we analyzed. So let me give an example of how we analyze that. So here at the top is a person who was disciplined on this date. They were disciplined for 4 offenses, convicted of 4 offenses. And we methodically went through and compared what they were convicted for to their complaint history. At the bottom is a complaint history. This person had 2 prior close complaints. And the red shows that what they were convicted of showed up in a complaint history, and specifically a complaint that was closed without discipline. So for each person, we were able to determine if whether or not they had a previously closed complaint that was closed for an offense category for which they were ultimately disciplined. And we do an analysis on which of these offense categories rose to the top in terms of frequency. So after we analyzed the data for every single person and gathered these pieces of information, we concluded, we stepped back and looked at 373 people, 83% were convicted of an offense that was previously dismissed. So let's start now talking about what people are convicted for. Here are 25 categories. And as you can see, the category of client neglect / abandonment rose to the top as the one that people are most convicted of, most frequently convicted of. Remember, so these bars do not add up to 100% because people are convicted of multiple things often. So this is just showing for 70% were disciplined for this category. 66% were convicted for professional integrity / honesty. 41% client trust funds, etc. So this is sorted from the most frequent to the least frequent. So now the question becomes, for the people, say for example, who were convicted of client abandonment, what percent of them previously had a close complaint for that very same category? So that's this analysis here. So it was 261 respondents who were disciplined for client neglect and abandonment. And of them, 87% had at least one prior close complaint related to that exact category. So like I said, we just analyzed categories. It may not have been the exact offense. Each one of these offense categories have multiple codes running like 2 codes, 2 offense allegations, and then it's the specific allegations up to like 20 or more. So it may not be the specific allegation, but it's within the same bucket. So 87% of people who were disciplined for client neglect had this in their complaint history. So this next slide is a little busy, but the way you interpret it is this. The gray bar is the bar that shows the percent of all respondents who were convicted of this category of offense. The blue bar is the exact analysis that I showed you on the previous slide. So there's the 87% for the client neglected and abandonment. Then it's literally the same analysis for every single bucket of allegations here. And so we sorted this by the blue bars so that you can see which of the offense categories rise to the top with regards to having high shares of people who are being convicted of things that ultimately were part of their complaint history. And so we put this little dotted line here to show that there are 7 categories in misconduct where more than 50% of the respondents who are convicted of something, they also have a prior post complaint for that same misconduct. Okay, so our conclusion is that the vast majority of attorneys who are disciplined for the first time do have a complaint in their complaint history that was closed without discipline. 40% had 1 to 5 complaints, but the safe bar received complaints for these attorneys over 8 to 10 year period prior to their discipline. And I'll just get to the last one. There are several categories of misconduct where the majority of respondents received prior complaints similar to their misconduct for which they're ultimately disciplined. So I can take some questions here. I'm going to stop sharing the screen and we can just run any of these slides or open up for discussion.
All right, any questions for any of the presenters? All right, I'm going to go first with Mr. Larkin.
Lisa, thanks so much. You and your team did fantastic work. Cutting edge, really informative work. I had 2 principal takeaways. I'm on this work stream. And we were stuck because we needed more data. And I think Lisa and team have done a good job here. In terms, and I'm going back to George's presentation, which was very helpful as well. My takeaway from the effort to expunge closed files is that for people I call frequent flyers, lawyers with a lot of investigations that get serially closed, the expungement will never kick in because they'll always have a pending investigation. And if that's the target group of, I'll call them frequent flyers, forgive the slang, then we're never gonna, that expungement will never address the concerns identified in the Farkas report. Then I want to go to Lisa's data and say, I'm not surprised that lawyers whom California is disciplining and Illinois and every other place in the world has a large number of complaints against a large percentage of lawyers disciplined. We receive those complaints. They're low level, they're close, they're not quite what we want to what we think is meritorious in filing a complaint, but eventually there's a collection of complaints. And if you're under the expungement, all the other complaints would still be available because there always is a new investigation coming in. So that concern isn't remediated. But I want to suggest the idea of addressing closed complaints may be too narrow, and suggest that really, and I've seen other states have success with this, is front loading the resource allocation to address the selection of complaints that may not warrant discipline. And maybe Melanie and George, you'll say you're doing this already, but to me, we've had some success, and we're not successful on this at all yet, of catching the attention of the lawyer with some remedial effort. We have an example. We'll call in a lawyer, hopefully with counsel, and say, we've seen this story before. Here are the 3 or 4 factors you got to clean up your practice on, or else you're going to be that person in 3 or 4 years who is disciplined. So it's a resource allocation. It's you're under a tremendous amount of time pressure. And I think the California bar is doing a great job. So please don't take this as anyone thinking you're not, or that everyone has the answers, but the data is compelling. Can we get to these people earlier? And I know you have a proactive assessment program coming out of a different unit of the bar, and maybe that's the answer. I don't know. I'm enthused by the information you've done, and you are doing stuff that no one else is doing. So kudos to your willingness to peek under the hood. Those are the only comments I have at this moment, but I'm happy to be part of the process here.
All right, thank you, Mr. Larkin. Ms. Buffington, I saw your hand was up. Did you still wish to address the body?
Yes, just real quickly, please. So Ms. Chavez, I was looking at your presentation. 40% of attorneys that are disciplined had prior closed complaints over an 8 to 10 year period. But I think one of the issues that we are this group subcommittee, commission is tasked with trying to figure out is, exactly how those closed complaints, how it's factoring into future discipline. So I know at least I believe last year, OCTC implemented, if there's a closed complaint without discipline, it's archived after 5 years. Am I correct or am I not correct on that?
Yes, you're correct.
Okay, so if we're still looking at complaints, closed complaints, prior closed complaints over an 8 to 10 year period, and this may not be a question for you, Ms. Chavez, how does that correlate with the archiving of the closed complaints without prior discipline after 5 years? And I understand that OCTC can access prior closed complaints that are archived. I don't think that's a question for you, Ms. Chavez.
So I can try and answer.
Okay.
I think we're talking about two different things. When they're archived, they're not totally removed from the system. They're still in our case management system, so they can be accessed, for example, for data analysis purposes, which is how Araya looked back more than 5 years so that they could track patterns to see what's going on. But for purposes of our attorneys and investigators, they can't look at them in connection with making decisions as to how to handle current complaints. So they're still available for data purposes, but they're not available to our investigators or attorneys for purposes of making decisions in current cases. Does that answer?
Yes, thank you very much.
All right, and Ms. Buffington, anything else?
Oh, thank you.
All right, thank you. Ms. Bell.
Thank you. Yeah, I feel like I must be missing something really obvious here, but why wouldn't the attorneys always be told that a complaint is filed against them? What's the downside of telling them? And is it just a burdensome on the office, or is there some reason why we don't trust attorneys with this information? What am I missing?
The working group did discuss that issue, and there are a couple reasons, and I don't know if Steve or Melanie or George wants to discuss them, but briefly, they discussed that it's a workload issue. I mean, we could automate a letter that goes out to 15,000 attorneys, but once you get that letter, how many calls are going to be generated to our call center where people are wanting to know? Plus, if you know that by doing a complaint, the attorney is going to be notified no matter what, it could discourage some people from complaining because they know that their attorney is going to know this. So I think it's mostly a workload issue, but I would turn it over to Steve and Melanie if they want to add anything.
I'll add something. There is a workload issue, just as Justin described. I mean, we have a large number of complaints every year. We close a large number of complaints every year. And as Justin alluded to, it's not just the generation of the letter and the sending that out. It's the follow-up from the respondent who then wants to give an explanation as to what happened, even though we've already said that there isn't insufficient evidence to move it forward, but they nonetheless would engage in a colloquy back and forth of, well, here's the explanation and this shouldn't have been complained about. And there's really nothing for us to do at that point anyway. Also significant, I think, is just the Sorry, I lost it. Melanie, help me out here. What was I thinking? The other piece is the
other significant piece you were going to comment on is the fear that revealing complaints, even though they're closed to attorneys, will serve as a deterrent to complainants coming forward. We want to make sure that complainants who do step forward, who are often stepping forward about their own prior attorneys, don't fear any form of retaliation or anything else, just if their complaint is closed.
That is a great point. And it also reminds me of what I neglected to say, and that was I believe there was a topic came up during the meetings about malpractice insurance, and whether once somebody was on notice that they had received complaints, whether they would have to then declare that or something along those lines. Can somebody who was maybe involved refresh my memory on that issue?
Yeah, that's correct. I think, and I don't know if Ellen's on the call now or not, but Discipline Defense Counsel brought up that issue of, now that they've been notified of this, is this something that they have to do when they're applying for malpractice insurance or some sort of insurance, I think is the point that was brought up.
And I think specifically there was an idea that it also might affect the lawyers standing at a firm, because the firm would know about it by definition, probably has to raise it with the managing partner, and it could have a chilling impact on the lawyer's progression at the firm or standing.
I'll throw this out to OCTC. Are there situations where OCTC will write a letter to a lawyer who has been complained about, but the issue has been, is not being pursued? Do you write letters of instruction, education in certain situations?
So I will say that we regularly have contact with respondents at the intake level when we're talking about bank issues. So when we're getting NSF fund notifications. And then otherwise, I would say we could have contact with the respondent if it's an issue about returning a file, for example. We might send a letter that says, return this person's file, or that the client has complained that the attorney is not calling them back. We might send them a directional letter that says, call your client back. And then if those things aren't resolved, then we can pursue the complaint.
And then I know that we've received at the board level some presentations on a unit that handles, I think, situations like you just described, where something that could be as easy as giving the client back their file. Is that the unit that you presented on previously? Or is that a different one? Kind of like a quick response.
I think you're talking about maybe the expediter teams.
Yes, the expediter. Yeah.
In most, those cases have moved forward to investigation if they're assigned expediter teams. And in many instances, we will have contact with the respondent during the investigation stage. It might be just by telephone, however, email. But in most instances, the respondent will know about it by the time it gets to investigations.
All right. Any other questions for Justin, Lisa, any of the presenters?
I just wanted to add that our analysis of other states that we shared with the working group showed that 13 other jurisdictions report reaching out to respondents to alert them of prior post complaints, and a few explicitly said in our survey that they do it to be proactive, to be preventative. Those states have very low case volumes. So, for example, I think like the most another state had that I could find data on was like 5,000 complaints a year compared to our 15,000. But there were 13 other jurisdictions, and I think that was something that motivated this working group to learn more about why we don't do that here in California. So we had all those discussions.
Okay. All right. Thank you, Lisa. Mr. Larkin.
Just to clarify, Lisa, in terms of the investigative data you showed us, does that include cases referred actually to investigation or some closed without investigation?
So it was closed regardless of stage, but the majority of those cases were closed in intake.
Thank you. I mean, if you go ahead, I'm sorry.
Yes, no, so those are all closed complaints without discipline. The majority of those complaints are closed with intake, in which case the respondent would not know. For cases that didn't get an investigation open but were ultimately closed, in those cases, yes, the respondents were alerted because that was alerted of an investigation.
Thanks.
All right, so any other questions? Justin, do you and staff need any direction from this body going forward?
Well, I think I do. We kind of presented, I think Lisa's presentation is great to get into the numbers, but I don't know if anybody in looking at that presentation or anybody has any general ideas on moving this discussion forward. Are there areas where they think that we should notify respondent? Because I know we just gave a lot of timeframes, and maybe the request is for us to put this in a report and bring it back with possible recommendations. But right now we've just kind of presented things, and the working group hasn't coalesced around any real recommendations, and it's because we just added more information to the discussion. But I'm wondering how we should move forward. Was there anything that stood out right now, or is this something that people want, just to take a look? We could write it up, the same information that was in the presentation, and bring it back.
All right, Ms. Rosenblatt.
The chart that I really appreciated from Lisa Chavez was because it makes it so clear what are the categories of the complaints and the percentage. That was gold, and I think that in any discussion that we have, that's a grounding chart. So I appreciated that very much, Lisa.
You're welcome.
Yes, Ms. Bell.
I mean, I guess I would just suggest that looking at that chart of those categories, that we have a pretty low bar, that we, like, if we're looking at, I wouldn't cut it off at 50%, for example. Like if there's got categories where they're 30% or 40% likely to have a repeat offender, basically, then I can't see why we wouldn't want to lean towards sending notice in those cases. I guess that's just my feeling, but that's what I would want to see.
I think we're definitely talking about resources, and one of the things that at the board level we've talked about is using resources, a finite number of resources. Do we want to use those on pursuing complaints that have more of a likelihood of harming the public, and investigating those and pursuing those to prosecution? And so, certainly something that the Board of Trustees is talking about. Mr. Larkin.
Brandon, I think pursuing the prosecution can be a good use of resources, but the chase is, I think, getting to someone before they need to be prosecuted. And that's a harder sell in any organization that has resource issues itself. That's true across the country. So we get 5,000 complaints. We have about 30 lawyers who are investigating those complaints and prosecutions that result. So it seems intuitive to me that if resource, and this is beyond the narrowness of our work stream here, but if resources can be brought to bear on those whose the data shows are likely to be at risk early enough to intervene and give them a chance to right the ship, that could be, at least on a pilot basis, worth seeing whether it has any merit. So I'm breaking the mold a little bit here. from what our work stream had considered. But I take liberty because Lisa has informed us of stuff we didn't know.
Yeah, I think certainly all these comments really kind of go to the tension that we have in a complaint-driven system. So we primarily are driven by individuals who complain against attorneys. Now that we have these complaints, what do we do with them? Is there a way that we can use them as a teaching moment, to intervene in these types of situations with some sort of education, with some sort of proactive approach? And that's definitely something that Ms. Chen, who's the chair of RAD, she has talked about quite a bit during the RAD meetings. And then even from a planning standpoint, the Board of Trustees is looking at ways that we can take those proactive measures. So a person is not being, that their first experience with the bar is not one in the discipline system, but rather ways that we can keep them out. And so reduce the number of potential victims. And so, that's one aspect. The other aspect is, archiving complaints, making sure that there isn't a disparate impact on individuals, but also recognizing that the number of increased complaints, and according to the data that we saw today, is some predictor of future misconduct. And so, how do we as a public protection agency use that data and use it in a smart way to ensure that the public is protected? All right, Ms. King.
Thank you. I think the data and the charts were extremely helpful. I was wondering if there was any input from any of the investigators from the State Bar of California. Thank you.
I'm sorry, your point about the analysis or the conclusions of input on what?
I was just wondering, of the people who are working in the field, the investigators and the attorneys, they have a unique position. And I was wondering if they had any input as to what would be an effective path to take and what to pursue.
Mr. Cardona.
So, I think these are things that, so yes, the investigators would have input, and I think they probably would agree that, as Mr. Larkin raised, to the extent we can identify people who, taking early steps to intervene will have effect and remove them from a later disciplinary process, it might actually end up saving resources, and that we can hopefully divert people out of the disciplinary stream, which takes more time than potentially just sending a letter and getting someone out. So to the extent we can do that, I think that would make a lot of sense. And I think there are a number of questions that are posed by that, which is, what's the form of the letter? How are we going to address follow-up inquiries? Are we going to reveal the identity of the complainant or the specific facts, or are we just going to give a general notice that, we've received a complaint in this area, here are some resources you can look at to get up to speed on your obligations in this area, which would avoid the potential retaliation against the complainant. So I think these are all questions that would need to be addressed, and perhaps that's stuff that the working group could talk about in terms of coming up with some proposals as to what might be an effective proposal to do this, balancing kind of resources against hopefully early intervention that would avoid the need to put more resources in down the road. I don't know if that, I hope that answers your question.
Yes, thank you.
All right, so then as far as staff action going forward.
I think I have enough, and I probably will want to get the working group together one time in between now and then to vet some of these things and go over the recommendations to kind of finalize. So I think I have enough so we can move on.
Okay. All right. All right, and next item D, the Progressive Discipline Group.
Yes. So George is going to present on the Progressive Discipline Group. I will just share my topical slide and just know that the Progressive Discipline Group has met several times. It's another meaty discussion for mid-afternoon. So thanks everyone for hanging in there. The goal is to kind of really examine the standards and whether or not there need to be changes to the standards, because the standards were developed over time. The Supreme Court has their opinions on the standards. And so the working group has really looked at whether or not there needs to be change to the standards. And then if there are going to be change to the standards, are there areas where discretion should be increased? They talked a lot about the differences between criminal courts and criminal courts, and obviously licensing agencies are administrative courts. So I'm now going to stop sharing, but these are kind of the discussions that we've had at the Progressive Discipline. And on some areas we've made progress, in some areas I think we've kind of stalled on the discussion on what to do potentially. So George, if you want to take it over.
Let me share my screen. So I apologize to members of the working group. This is going to be kind of a recap of what I presented to the working group, but it's just basically an outline of what the standards are and where they kind of give discretion already in terms of progressive discipline. So obviously the standards for attorney sanctions for professional misconduct based on the State Bar Act, published opinions from the review department and Supreme Court decisions. The Supreme Court affords them great weight and according to the standards accepts a disciplinary recommendation consistent with them unless it has grave doubts. So the standards themselves talk about prior records of discipline and define what those are, previous imposition of recommendation of discipline. It lays out what those are and then has a number of situations in which those are looked at in terms of imposing discipline in a current case. So for example, under standard 1.5a, a prior record of discipline is an aggravating circumstance, has to be proved by the state bar by clear and convincing evidence, but then can be considered an aggravation. So that's the most general use of a prior record of discipline. And then there are more specifics in the standards. So if you have a single prior discipline, standard 1.8a says, if you have a single prior record of discipline, the sanction for the current discipline must be greater than the previously imposed sanction unless, and then it lays out certain criteria, unless it was so remote in time and wasn't serious enough that imposing greater discipline would be manifestly unjust. So in essence, there's discretion not to impose a greater sanction where it would be manifestly unjust under these criteria, remote in time, not serious enough. So the standards themselves build in criteria from which you would depart from the presumption of progressive discipline, i.e. a greater sanction for the new current discipline as opposed to the prior. So that's the effect of a single prior discipline. The standards then also have a standard that says what's the effect of two or more prior disciplines. So if you're at your third discipline, and it says here that basically disbarment is appropriate in one of these circumstances. If you had an actual suspension in one of your prior disciplinary matters, there's a pattern of misconduct, or the prior disciplinary matters coupled with the current record show an unwillingness to conform to ethical responsibilities. So disbarment under any of those circumstances is the presumptive discipline if you have two or more prior records, unless, and then again it lays out, unless the most compelling mitigating circumstances predominate or the misconduct underlying the prior discipline occurred during the same time period. So again, the standards themselves lay out criteria for when you would not use the presumption of disbarment in this case. So again, those are discretion where there's the most compelling mitigating circumstances or the misconduct underlying the prior discipline occurred during the same time period. And that's derived from Supreme Court case law, which underlies the standards. Mitigating factors, the standards lay out a host of mitigating factors. This is a list, and I'm not going to go through them all, but there's a clear set of mitigating factors that would be looked at for purposes of determining whether the mitigating factors clearly predominate, and that presumption of disbarment or presumption of progressive discipline shouldn't be applied. So that's kind of within the standards. And then the standards themselves also recognize that there can be deviations from the standards, which would include potentially deviations from the progressive disciplinary standards set out in 1.88A and 1.8B. Any disciplinary recommendation that deviates has to include clear reasons for the departure. So again, courts have discretion to depart, to deviate from the standards themselves, as long as there are clear reasons for that departure. And some of the factors, some of the things that courts might look at would relate to the rationale for progressive discipline, which has been set out in a series of decisions, the rationale for these kind of progressive disciplinary standards, pattern of misconduct, breaches of oath, duties have become commonplace, suggesting that there is the need for greater discipline. And unwillingness or inability to learn from past professional mistakes, again, suggesting that there needs to be more to try and send that message more completely. So these are kind of the underlying rationales. So what the working group talked about was kind of two general questions. First, both the Supreme Court and the standards make clear that progressive discipline should be the norm with deviations limited. And one question is that what the commission wants to agree with, or does it want to propose something different? And Justin can correct me, but it seemed like the working group came to the conclusion that they basically agreed with this approach, that progressive discipline should be the norm with some limited set of deviations. And then the second question is, if there are limited deviations, the Supreme Court and the standards lay out what those circumstances are and set out what are fairly narrow circumstances for not imposing progressive discipline. For example, the most compelling mitigating circumstances clearly predominate. So a second question is, does the commission want to propose some different circumstances or lay out different circumstances that the commission believes should justify a departure from the norm of progressive discipline? And on that, and again, Justin can correct me, but the working group didn't arrive at a conclusion and thought that there was further discussion that should be had with the group as a whole on that. And that's the end of my presentation.
All right.
So I will stop sharing.
Okay. Does anybody have any questions for George or for Justin?
And I don't know, Judge Wang was in this conversation. I think she had to go. And I don't know if Ray is on the call or not. They were kind of in this. Hey,
yeah.
Ray.
Hey, I do. Okay.
We'll go ahead.
All right. Thank you. What I'm struggling with respect to progressive discipline is how do we, so again, bringing it back to the reason why we are all here gathered together, which is to address the disparate treatment of Black attorneys. And so my issue is, if we accept the fact that Black attorneys have been unfairly targeted, treated, or whatever you want to term, then how can we use their prior conduct, which, again, for argument's sake, we've accepted that they may have been unfairly prosecuted, for lack of a better term. Why should we use that prior conduct to progressively discipline them when that prior discipline that was imposed was flawed somewhat? And so that's my struggle. Now, I'm not sure if we can address it by perhaps saying some kind of mitigating factor that would capture that problem. But I do think it needs to be addressed, because the inherent problem is progressive discipline is assuming that the prior conduct was valid. And we're here because we've accepted that perhaps the treatment of Black attorneys in the past has not been so just. So that's my comment. Thank you.
All right, Miss Rosenblatt.
Just a comment. I'm appreciative of Mr. Buenaventura's concern. I think I'm seeing this issue of progressive discipline, however, needing in the standards. That it went by really fast, Mr. Cardona. So I didn't see that there was any reference to the seriousness of these issues. You know, the relative seriousness as calling for clear and convincing evidence. For example, there'll be clear and convincing evidence that someone, you know, 3 times was late in paying their bar dues, and, you know, from anywhere from 2 to 3 months, or didn't complete their MCLE, you know, twice, you know, in a 5-year period, you know, within the stated time, reporting time in February. So I'm just wondering, are these standards connected with a provision that the progressive discipline is really addressing serious violations? That's just my concern.
All right, do we have the data for that, Mr. Cardona?
So the standards themselves build into the initial discipline and subsequent discipline an assessment of seriousness. So the court looks at the underlying conduct itself, and there are different standards for different types of conduct. So the more serious conduct start from a higher point. And then obviously there are also aggravating factors and mitigating factors that the court balances in imposing discipline to try and further assess the seriousness. In terms of the progressive discipline standards, you know, the final one, standard 1.8b for disbarment, requires that one of the prior disciplines either involved an actual suspension, which would suggest that that underlying discipline was fairly serious to get to the level of an actual suspension, or demonstrates a pattern of misconduct, or demonstrates the lawyer's unwillingness or inability to conform to ethical responsibility. So in that sense, they build that in, but there is no specific reference in either of the two standards, 1.8a or 1.8b, no explicit reference to seriousness of the current conduct.
Because some place I am concerned that the measure of the seriousness impacts the, you know, has some kind of impact, some measurable impact on the rights or property or well-being of a client. The rule, but that there has been some kind of measurable financial or actual damage to clients or to, you know, just because somebody violates rules, like which rules are really have an impact on damaging, you know, the public's interest in a measurable way, not just scandalizing them or, you know, that the person is not so great a character. And in this, I'm very, very sympathetic to Mr. Buenaventura's concern and those of them, those addressing minority rights, because it's so easy to assume that persons who are minorities don't have the same character as the majority.
Anybody wish to discuss that further? Okay, Mr. Larkin.
Try to tread really carefully here. The FRCIS report says there is disparate impact on Black males in discipline. The Robertson report controlled for other factors, and it was a different outcome. we confront this issue all the time in our state as well. Years ago, one of the prominent defense counsel approached me and then my then bosses. And he was African American. He said, you know, Jerry and Carl and John, I represent a lot of Black male lawyers whom you're prosecuting. And in fact, they have done what you've charged them with doing. And they have enacted Don Hubert's suggestion. Those from the African American happen to be the facts were presented then. Let's do something, because there's no question, there's then and now in my mind, that most of these were organizationally driven complaints, client communication complaints. He said, let's fix this by helping to get ahead of this issue with my clients and solos generally, who never learn how to practice law effectively by organization, by client communication, by diligence. And so I like to frame it up that way better. But I acknowledge what the reports before us indicate. I acknowledge there's a disparate impact in your jurisdiction and mine, discipline on Black male lawyers. So I don't think it's a capacity question at all. I don't think it is that at all. I think it is perhaps a undercapitalization at times. It is a lack of good resources and client base, and a struggling practice that we see across the solo sector. But Ray, I'm anxious for your response to my comments. I've tried to be careful and nuanced, and maybe I wasn't. Please jump back in.
So thank you, Jerry. So what I would say with respect to your friend's discussion with you is that I'm interested in actually knowing if he followed up with that discussion by saying, yeah, maybe my clients did do what they did, but were they unfairly prosecuted or targeted as compared to their Caucasian counterparts? So that's what I think the concern should be, more so on how do we address the progressive discipline issue moving forward. And so again, I think we have accepted that they have been treated unfairly, and it's just a matter of how do we move forward with either undoing it or not using that prior conduct against them. Because I think from what I remember in hearing the statute, that when you have one prior discipline, that you shall be progressively disciplined. And I think that's the problem that I have, because that one prior discipline could have been the result of a system that had built in systemic racism and the unfair treatment of Black men attorneys. Thank you.
Ray, let me just jump back in. Don, this is years ago, Don Hubert, he never questioned the fairness of our proceeding. We're all a lot more attuned, given the diversity, equity, and inclusion, our progress in that area, to implicit bias. So I just say that. I think that hopefully reinforces what you just said.
Thank you, Jerry.
So good, maybe a question for the panel is, because this is a complaint-driven system, State Bar needs to protect the public, needs to take allegations seriously and to investigate allegations of misconduct. Once those complaints are made, they're now in the system. We have data that shows that there is the potential that those with more complaints are more likely to recidivate. So, how do we as a ad hoc commission balance those I guess those realities with a desire to make sure that there is no disparate impact. And how do we, what recommendations does this body make to the Board of Trustees, and how we treat this data, and how we operate going forward. Ms. Good.
One discussion that the working group had that we were kicking around was building into the system discretion to depart, within the control of the state bar court judge, based upon the Farkas report and other issues. So that was one thing that we talked about doing. And I think, obviously, there's a lot more work to be done on this issue, but that was one point of discussion.
This has been brought up in another working group that I'm on, and it revolves around the probation redesign, or probation department redesign. But the more discretionary tools that are built into a system, the more potential you have for disparate impact on individuals. And so that's not to say that you have zero discretion, but when you do, what safeguards are put into place to make sure that one individual is not being treated differently than another. So I think that people recognize the kind of that tension between those two things. And so, Justin, kind of in that vein, what direction is staff looking for regarding this discussion and steps moving forward, and any recommendations the ad hoc commission takes?
So I think this has been a useful discussion. I know Judge Wang was really important in the discussions that we've had, and I know she had to step away, but it's really the struggle of, do you modify the standards or do anything, because the case law behind it, there's not a lot of discretion. And that's the balance, because with increased discretion could potentially get increased disparity. So she really did a good job of articulating the pros and cons of this. And so there was a lot of focus on standard 1.8. And at one point in time, because standard 1.8 talks about the sanction must be greater, and there was talk about, should we modify that from must to may, or things of that nature. That was brought up at the working group. I don't know, in moving this forward, the working groups kind of hit an impasse as to what to do to move it forward. So I was kind of bringing it to the full commission to see if we can, move the discussion forward, knowing now that certain working group members aren't here. I know there's a couple hands raised, but I can always take this back to the working group if there's not clear direction right now, I guess.
All right, I'll go to the couple of raised hands, then we'll circle back to that. Ms. Bell.
Yeah, I just wanted to say that from looking at the parallel to mandatory minimum sentences in the criminal justice system, I think that the research is actually the opposite of what folks are saying, in that I believe the research is that the mandatory minimums have increased the disparate impact, and adding discretion isn't going to add to the disparate impact. It's going to help fix it. I think that that's the research from the criminal justice system. And I think, we don't need to reinvent the wheel here. If that's correct, if what I'm saying is correct, then, then I think we need to look at that. It sort of changes the angle that what I'm hearing people say, that maybe your concern isn't really based on the data, in terms of worrying that adding discretion is going to somehow make things worse. I'm not sure that's right. I think we can look to other places where there's analogies, and we can look at the research, and because if that's not correct, then we do need to add that discretion back in, because without it, we see where we've gotten, and we, to Ray's point, we haven't, we need to address that problem.
So Justin, do you know, was there a discussion on any recent studies, as mentioned by Ms. Bell?
I don't recall. I know Steve, can you, there was a lot of expertise on the criminal side. And so there was a lot of discussion on the parallels or the big differences between the two sides. I don't know if anyone wants to speak to that.
I don't recall a discussion about studies that have shown that reinstituting discretion has resolved problems previously existing. Obviously, I think our criminal justice system has been a pendulum for many, many years that has swung from one side to the other. And so I don't know, but I'm not familiar with those studies.
So perhaps we could do some follow-up research on that and send that back to the working group and
definitely
have that back to the full commission. Okay. All right, let's see, going on. Mr. Lear, I think you were next.
Thank you, Brandon. So my comment's less about disparate impact and more about the experiences that I've had with progressive discipline. And I'll just give you a hypothetical of the situation where the essentially shows the progressive discipline does not work, at least in this particular type of circumstance. Let's take a hypothetical where a respondent, let's say 5 years ago, had engaged in conduct that resulted in 3 months of actual discipline based on moral turpitude. 5 years later, there is a failure to communicate, where in this situation, in my hypothetical, that there's no defense to that. It's just a simple failure to communicate. In the spectrum of misconduct, all would agree that moral turpitude is serious, and all would agree that failure to communicate would be on the lower end of the spectrum. In that circumstance, in that prosecution, with the progressive discipline system the way that it is, the next level of progressive discipline would be a 6-month actual suspension. And my argument that I think all would agree with is that a 6-month actual suspension in the context of my hypothetical is not commensurate with the misconduct. That's how the progressive discipline works. I understand that there are other hypotheticals that maybe justify progressive discipline, but in light of the hypothetical that I gave you, which is what happens in a progressive discipline system, I'm an advocate in favor of adding more discretion, allowing both OCTC and or the court to have the discretion to mete out discipline that in my hypothetical would be fair, because a failure to communicate in my hypothetical could be as low as a private reproval to a public reproval. So in my hypothetical, again, we are we are creating, we have failed. We have disciplined somebody 6 months actual for very minimal conduct that was, and again, this is 5 years later, and I chose the facts, I get it. It supports my argument. But I think that the only way that you can deal with my hypothetical in a fair way is to create more discretion to depart from the progressive discipline standards. And again, I'm not addressing disparate impact. I understand that that's a big issue here. I don't have a comment about that. I'm just giving you an example. And I don't know that I've had that real life example, but I've had many that are like it.
All right, going on to, I think Ms. Anderson was next.
Well, I would just say that in viewing progressive discipline, and you're talking about individuals and individual actions by each person and what has happened to them, plus disparate impact and systemic racism that has obviously occurred in certain situations, I think discretion is necessary in order to even out the playing field or to bring it back. Just as when you, in the criminal system, you have the ability to strike a prior for instance, for driving under the influence, or strike a prior for other conduct. I think that we should have the ability to strike prior conduct, even if it's necessary to maybe convene a special panel to look at those priors before being able to use them in progressive disciplinary actions. And that may be one approach, is that if a person has a prior disciplinary action that we believe was unfairly imposed, or was not necessarily given the same treatment as others, that there be the opportunity for a review and the ability to strike that prior conduct so that it is not impact their current disciplinary action.
All right, thank you for that comment. Ms. Pansky.
Thank you. First of all, I apologize. I missed the first part of this. I had to make an appearance on a motion in federal court, so I had to jump off for a little bit. But I want to point out, similar to our discussion earlier today about the fact that, contrary to maybe what we're assuming, there's already some flexibility built into the system. And so, just as not every conviction is required to be transmitted, if you look at standard 1.8, that talks about effective prior discipline, what it actually says is that if the lawyer has a single record of prior discipline, the sanction must be greater than the previously imposed sanction, unless the prior discipline was so remote in time and the previous misconduct was not serious enough that imposing greater discipline would be manifestly unjust. And it also goes on in subsection B to say that while disbarment would be the presumed disposition if the respondent has 2 prior degrees of discipline, that's not true if extenuating and mitigating circumstances prevail. So I think we're starting from the wrong point. We shouldn't be starting from the point that the rule mandates and there's no flexibility, because that's not what the standard says. So I think we should be starting from the point of acknowledging that even in the current standards, it's explicitly recognized that each case has to be decided on its own merits, and you have to look at all of the circumstances surrounding the misconduct, and most importantly, the mitigating circumstances. That's where we should be starting from.
All right, Steve, I saw you had your hand up at one point. Did you wish to comment on anything? Okay. All right, Justin, any other discussion that you believe would help direct staff?
No, I think the direction, doing a little further research that Ms. Bell suggested, and there have been more discussions. I can bring this back to the working group and hopefully move it forward and get something for the full commission.
All right, item E was taken off calendar, so staff can continue to study that item. And then I think we're going to finish up with Ms. Wilson on the update on the special discipline case audit issues.
Sure, let me pull this up. And while I'm doing that, just thank you guys. I think this has been a really rich set of discussions today. Fortunately, I'm having trouble pulling up the presentation. Here we go. So I want to thank Commission Member Buffington, who has been staying on top of some of the work of the state bar outside of this commission, and asked, I think, a really fair question of me, which was why the recommendations that the board passed in November related to the Client Trust Account Protection Program had not been brought forward to this commission. And so I told her that I would present the recommendations here. The reason why, and this may have been a mistake, that this issue was not brought forward to the commission is that fairly early on, the commission did appear to decide not to make recommendations in the area of client trust account management. But let me just quickly walk through these recommendations, and then you may all decide that you do want to weigh in somehow. So I'll walk through these fairly quickly. So the board established a special discipline case audit committee last year. And that committee had a fairly long charge, but with respect to the issues I'm going to discuss today, you can see the charge here. The committee had an expansive charge in a fairly short time frame within which it was working. I believe it was less than 3 months that this committee was tasked with coming up with recommendations. And all of you, it's no surprise, given the issues that we faced or that were raised by the Tom Girardi situation, that the board wanted a systemic review of how and to what extent client trust accounts are being managed or overseen by the state bar. So just really quickly, and I'm no expert on this, and there's plenty of experts on the call, but just to share that one of the things that the special committee reviewed were the rules that got, I don't want to go this way here, the rules that govern client trust account management. And our primary rule is rule 1.15. And so the committee kind of reviewed the rules and made some determinations as to whether changes were needed to the rules that I will discuss in a moment. But what the committee also learned is that our primary vehicle, just like you've been talking here about how our primary vehicle in general for getting information about concerns about attorney misconduct is complaints. We are a reactive system. The committee learned that we receive information about concerns that clients or others have with client trust account management, primarily from clients or through reportable action bank matters. And this, of course, was a big focus of the Farkas report, this latter item, the reportable action bank matters. And I would say in terms of the division of complaints, looking at our data, about 60% of client trust account complaints come from clients, another 40% from the reportable action bank matters. But one of the things we learned that was of concern is that there's no requirement to report any client trust account information to the state bar. There is a requirement to report IOLTA accounts. So that's those pooled trust accounts. That data does have to be reported to the state bar, but not individual client trust accounts. So we have no idea how many are out there or what the balances are. And I can tell you that from information we've gathered from other jurisdictions much smaller than ours, it is safe to assume that there are billions, many billions of dollars on deposit in client trust accounts in California. Another challenge we have, in addition to not knowing, how many trust accounts there are or how much money is in those trust accounts, is that the state bar cannot assess attorney practices. Are they doing a good job or are they compliant with the rules with respect to client trust account management absent a formal disciplinary investigation? So here, in addition to learning about what the current rules are that govern client trust account management, getting some information about what we do and do not know, the committee also looked at all of the client trust account management programs that are in effect in other jurisdictions. And so I'm not going to go through these with you because there's a lot of detail, but the point as I go through these slides is you will see that many states have some form of a trust account audit program. So what this means is you're not solely reliant on complaints to get information about client trust accounts and to review client trust account practices. In addition to looking at what's going on in the US, we also took a look at what is going on in Canada in particular, as well as other countries, particularly in the EU. But Canada has some very robust models that ultimately the special committee decided to model its recommendations after. And I would really point out here the Law Society of Alberta, a very comprehensive program in place there. So the key takeaways after doing a lot of information gathering or review is that many state bars do audit client trust accounts, and that there are robust programs in place in other countries. And again, the Canadian programs really served as a model for our work. We also, I didn't include those slides here, but looked at models in other forms of state government. For example, we all know about escrow accounts when you buy a house, but I didn't know that there are all types of other escrow accounts, including, for example, for big theater productions and for movie productions. And escrow accounts, all non-real estate escrow accounts, are audited every year. Funeral accounts, if you put a deposit down for a funeral plot at a cemetery, all of those accounts are audited every year. So there are many other examples of trust accounts being audited in other parts of our state government. And so the special committee took from that, and that State Bar is behind in not having any type of proactive oversight of client trust accounts. So with that, the committee voted to establish a client trust account protection program in California. And so the main components of that program are listed here. One, there would be annual registration of all trust accounts. Again, currently attorneys are only required to report on their IOLTA accounts. And along with that registration, there would be a certification of compliance with the rules. And for those who manage client trust accounts, an annual self-assessment. So basically, you know, here are the 10 key things that you need to do to responsibly manage a client trust account. Are you doing them? Yes, no, perhaps a little bit more robust than that. Then the next phase would be compliance review. Compliance reviews would be required for a random sample and a risk assessment-based sample of attorneys. So not all attorneys who have client trust accounts. And those reviews would be done by CPAs. Then based on that compliance review, a number of things could happen. The files could be closed. There could be a notice of deficiencies and requirements to correct. There could be a formal audit. There could be referral to discipline. Another component of the program, as the board has approved it or designed it, is enhanced attorney education and public and client education about their rights, including new affirmative attorney disclosure requirements. The estimated cost was provided to the board. Estimate this to cost about a little under $3.5 million annually, based on a review of what other jurisdictions have done. And that would allow about 500 reviews or audits annually. Statutory and rule authority is needed to implement. So very little of this program can be implemented on the state bar's own motion, although the initial phase of requiring account information can be. In terms of the rule amendments, I mentioned that the committee identified some rule amendments needed. So the first one is about the timeline for disbursement of the trust account. Right now, there is a fairly amorphous standard. There's no bright line rule, and the current rule depends on client request. The committee has asked COPRAC, our rules gurus at the State Bar Committee, to establish or propose modifications to the rule that would essentially establish a bright line rule for distribution of client trust funds, and eliminate the burden, shift the burden from being on the client to request disbursement to being on the attorney to initiate disbursement based on the timeline. Another rule amendment, actually this one, the recommendation or the ask of COPRAC is that a comment be drafted. This would be clarification of rule point 1.4 regarding the requirement that attorneys have to keep clients informed of what is going on in their representation, and that includes information about the trust account and settlements. There were other aspects of the committee's charge, and I'll just briefly touch on them here. They really had to do with looking at mandatory malpractice insurance and bonding, and whether or not those would offer additional protections in this space. We know legal malpractice insurance is not required in California. We've done a very exhaustive study of this topic as recently as 2019. But the committee has asked that it be revisited again in light of in response to this question of whether mandatory malpractice insurance would in fact be protective of clients with respect to CTA mismanagement, and in the alternative, potentially looking at bonding requirements. So no recommendations were made in this regard, but rather a request or directive to staff to bring forward recommendations at a later date. In terms of the timeline, we are in this initial phase now where we're really looking at that piece, sort of the step one, which would be registration of trust accounts and certification of compliance with the rules. And you can see here that the first sort of formal action on that is expected in March of this year. Also in March, COPRAC is expected to bring forward to the board proposed revisions to the rules that I highlighted earlier, and those would go out for public comment. And I believe we would also be issuing out for public comment the self-reporting form, even though it is not a formal rule proposal. Later on in the year, we would be looking at our education and professional development components, and that has to do in part with this self-assessment. And the self-assessment form would be completed. And in addition to that, the analysis of what would constitute a flag vis-a-vis the self-assessment data, that will be identified and presented to the board. So that's all around June of 2022. And also this year, we will focus on what the expanded public education and client outreach needs to look like. It's not until 2023 that we would contemplate implementing, if we have the authority to do so, compliance reviews and audits. Also in 2023, those recommendations would come forward about malpractice insurance and other forms of insurance, including bonds. So those are the recommendations that were adopted by the board. And I've given you a sense of the timeline. And again, because this commission made a decision at some point early on, I believe, not to explore recommendations in the area of client trust account management, I did not think about bringing these forward to you before they went to the board. And so my apologies if that was not appropriate. I don't think it's too late for the commission to weigh in if you so choose. I would say that in general, when we think about our current system, which again is complaint-based and reactive, and you think about this client trust account protection program, which is proactive and using a combination of both random design and risk-based design to identify attorneys, and really you're identifying trust accounts for further review and analysis, I think you address inherently some of the bias components that may lead to some attorneys being disproportionately complained about, and therefore disproportionately receiving discipline. You also have issues with those reportable action bank matters, where it's typically the lower volume accounts, attorneys that don't have as much money on deposit that they're able to move around to avoid the RAs, where we're receiving those reportable actions. So I think in designing a system that's less dependent on complaints and reportable actions, you are increasing the fairness of your system, and that's certainly our hope. So I'll just pause there, see if there's any questions or comments. And certainly Sean was on the special committee, Ruben, Brandon. I think we have many representatives, so others feel free to jump in as well.
All right, I see we have a couple of questions here, Ms. Rosenblatt.
Thank you, Ms. Wilson. Thanks for that overview. I have had the experience of both holding an IOLTA account into which I deposit client funds in advance of my service to my clients, and then the distinction of a client trust account, which was kind of crazy. It varies from bank to bank how to set these up. For example, to hold real estate funds prior to a judgment of dissolution of the property to settlement. And so there are two questions that arise in my mind. Well, one, the interest from a client trust account, for example, for real estate, goes to the client, not to the state bar. And I wonder if in your recommendations, that's made clear, because it isn't clear to me how supervision of the client trust accounts benefits the bar in the same way that the IOLTA accounts do, because the interest provides funds for the representation of clients who are indigent, or so that funds the state bars. Just I'm not quite sure how it works, but I explain it to my bank tellers as serving the state bar's interest in helping everybody have representation. This they understand, so they know that when I come in to distinguish, making it very careful to distinguish my business account deposits from my IOLTA account clients, which unfortunately are the same bank, they feel involved in some kind of service operation. I am not sure how to sell the supervision by the state bar of client trust accounts. For example, holding real estate funds on behalf of clients who are awaiting a division of the family court judge about who gets how much money from the sale of the house.
Okay, if the question is how to sell it, I think the point for us is our responsibility and our primary client is the public. So the intention is to protect the public, in this instance, the consumer. So you're right that the interest does not accrue to the state bar. The state bar does not have a monetary interest, but the state bar does have a public protection interest. And I think one of the things we learned through the process or the work of the special committee is that being solely reliant on complaints and reportable actions from banks is not, does not reflect the due diligence required to effectively oversee what, again, just based on what the data we got out of Canada, which only has 11,000 lawyers in Ontario, and over 1 billion on trust account deposit. I can only imagine that the numbers are staggering here in California. So that's really why, Eloise, it's to more proactively protect the public.
Well, my one more question is, you mentioned this, if these attorneys are randomly chosen to have an audit of their client trust accounts and the hundreds of thousands or the millions or the billions that are deposited, presumably somebody has to pay us for a CPA. Is that random audit costs requiring a CPA going to fall on the attorney who is randomly selected in order to comply?
Yes, that's how the program is currently designed. And I can tell you that the CPA portion, not a full audit, but the CPA portion, and again, the data we have from other jurisdictions suggests that would be about between $2,000 and $2,500 for that kind of a review. So yes, as currently drafted, that would fall on the attorney. Did you want me to call on people, Justin, or Brandon? Your call, sorry.
Yeah, if you want to call on people, I think Mr. Larkin's up next.
Okay.
want to jump ahead of Ellen. She was ahead of me.
My apologies.
Thank you, Jerry. I don't want to step on Jerry's toes, but my first point was going to be, I do think this is appropriate for our commission. We did have an extensive presentation early on about the reportable actions and how a number of states, including Illinois, do not discipline lawyers for the types of things that tend to get, pulled out or identified by some of the lower level reportable action, meaning the bank identifies a bounced check or a payment on insufficient funds. So I'll leave that to Jerry, but I do want to say that I am concerned that we are mindful of the distinction between lawyers who, to put it bluntly, are stealing client monies or other trust funds, and lawyers who run into problems because they're poor bookkeepers or because they have no education or training in financial record keeping. And we talked about this, and I thought that we had a fairly strong consensus that we would recommend moving away from discipline for the bookkeeping error type of problems. So I think that should go back on the agenda. I just want to make one more point, if you'll permit me. In fact, the State Bar has essentially always had the ability to audit. It's in Business and Professions Code section 6091 and 6091.1. Those sections were adopted in 1986. In fact, in virtually every case in which there is an investigation of lawyer conduct that has to do with the lawyer holding trust funds, the lawyer is already required to voluntarily produce all of their trust account records, including monthly statements, checks, deposit receipts, signature cards, everything. And if the lawyer does not produce everything that the State Bar requests, the State Bar already had the power and has the power to subpoena those records directly from the financial institution with no prior notice to the lawyer. The lawyer is not advised that these documents have been received by the Office of the Chief Trial Counsel until after the fact. I think that while I can't imagine anybody in the defense bar objecting to new bright line rules that will make it more clear to lawyers what they need to do, and certainly you're not going to hear any of us say anything to criticize efforts to safeguard against and appropriately discipline lawyers who misappropriate client funds. We shouldn't be under the impression that if you have lawyers who are going to steal client money, that a random audit is the solution. This all came about, this current proposal, because of press attention about one lawyer who allegedly stole something like $2 million from a client who had complained to the State Bar, and who that lawyer did not get disciplined for years. Okay, that has nothing to do with having more random audits. And the idea, which I didn't know, and I'm glad that it's now been made clear, that when these random audits occur, that the lawyer is going to have to bear the expense, even if it turns out that everything is pristine in that client trust account. I think we should look at that, because you're talking on one hand about lawyers who are solo or small firm practitioners who are not trained in client trust account record keeping or handling, who are ending up getting disciplined because many times of an error, and now they're going to have to bear a financial burden on top of it. I think that's the antithesis of what we had discussed earlier on with respect to whether it's fair for those lawyers to get disciplined.
So I think it probably would be good to figure out, Justin, if there is a working group that could vet this further, because I think many of the things that Ms. Pansky just stated are actually, many of those concerns are actually addressed in the full scope of the recommendations. For example, I think we were very clear that if there is a disciplinary investigation underway, OCTC can compel client trust account records, which is what you said, Ms. Piansky. We were focused on all of the situations in which there is no formal disciplinary action. We also spent a great deal of time talking about the real value of this being in attorney education and ultimately prevention. The very small percentage of cases, and we know this from other jurisdictions, that actually result in formal discipline. That is not the intent of the program. It actually is intended to, one, eliminate our current paradigm where we are solely complaint driven, and two, to more proactively have a vehicle for reaching out, touching attorneys, and providing education, some of it mandatory, via, for example, a mandatory self-assessment. I think that the cost issue is a fair one, certainly one that could be revisited. So it just may make sense, I think, for one of the committees, or I forgot if you guys are committees or subcommittees, to take this on, really look at the recommendations in depth and decide if you want to make formal comment to the board at its next meeting, where it will consider this effort, which will be at its March meeting.
And I'm more than happy to conduct a working group. Just so we know the timeline, the special committee met after this subcommittee. It came up in the fairness subcommittee. We made the presentation because Professor Robertson had some recommendations on the RA bank matters. And so we kind of went through this in depth and covered everything. And at that time, the subcommittee decided that it wasn't something that we were going to pursue. Obviously, subsequent, this special committee met, and so that's why we didn't present that at the time, because it happened after the fact. Now we're bringing it back to. But if the most efficient use of time is to get a working group that will need to meet, be flexible and meet within the next couple of weeks to kind of go over what was previously covered and then go over these recommendations, I'm more than happy to do that.
Do you want me to see if there's any volunteers at this point, or have
well, I think
people reach
Steve
out?
has his hand up. I don't know if he wants to
And
say
I think Janet has her hand up also.
Okay.
I can't see everybody. And Shanae.
All right, anybody else? Okay. If you,
I'd be happy to, if it's volunteers we're looking for, I'd be happy to be a volunteer in this, Brandon.
great. All right, we got Jerry, Steve, in addition to people already named. Excellent. All right, thank you for your.
Brandon, since I grouped up, I'll join too, since we're not limiting it to 2 people.
Okay.
If that's all right with you.
Absolutely.
So just so I'm clear, I have Janet, Jerry, Steve, and Sean.
Me too, I'm on it, Mr. Urick.
Okay.
All right.
Yeah, so I think these will need to be notice meetings because of the size of the group.
Yep. All right, excellent. Any further direction the staff needs regarding that working group?
No, I still see Steve.
Yeah.
Steve's hand and Ed. Yeah, okay.
Yep. All right, so going back to questions for Leah, I think Jerry, I think you were next.
Leah mentioned the educational focus. That's what I was going to talk about. I think that's really important.
I'm sorry. I'm having trouble hearing you.
So you mentioned the educational focus.
Right.
And that was what I was going to talk about. That's impressive.
All right, great, thanks. I think Steve was next.
Thank you. I also wanted to mention the education. It is, as Leah pointed out, the ones that actually end up in discipline are a very small percentage of the overall audits. Many more of them, as Ellen pointed out, result in just a, hey, have you thought about doing this differently type of thing? And it really is an education that I think is beneficial. I do want to point out that Business and Professions Code 6091 does say what Ellen said it said, except it is limited. It is limited to when the state bar receives a client complaint alleging that his or her trust fund is being mishandled. And so it does not provide the state bar with the tool that this type of program would provide. And it really does allow us to shift from that sort of reactionary into a very proactive system that would go out and educate the lawyers and hopefully prevent misconduct. And even frankly, just knowing that that audit program is out there may make people more careful about their client trust account handling.
All right, thanks for that, Steve. Ed.
I wanted to echo Ellen's comments and commend Leah for her comments. Experientially, I represent a lot of real estate brokerages. The California DRE has forever had a random audit process there. And my very jaded view is a couple of things. One, I don't think there's a client trust account in the world that doesn't have errors in it. Both lawyers, DRE licensees, you name it. And where I was concerned is that, that this was a setup for lawyers, law firms, where I think I could go in and find issues, problems with any client trust account there. And I thought this was just a ticket for discipline, which is essentially how it plays out with the DRE licensees. There's virtually never a DRE audit where there's not misconduct found. And then the negotiation really is, as Ellen has pointed out, whether it's intentional or whether it's something that's negligent. And then talking about mitigation, there are strict liability cases in the same way that they will be with the state bar. So I'm real pleased that the bar's focus here is on education rather than discipline, and hopefully that's exactly how it would play out. I think the DRE model is an interesting one for the working group to be aware of because they've been doing it for years. I will further note that, and this is, I suppose, an editorial and somewhat jaded view, that the DRE cost of audit is only assessed where there is wrongdoing found. And the jaded view there is that the DRE auditors work real hard to find some kind of impropriety in order to justify the 3 or 4 days that they have been at my clients' brokerages. Here, it sounded, what I heard from Leah, I think, is that the lawyer will bear the cost regardless. Maybe I heard that wrong. And I don't think that a lawyer should have to bear the cost of a random audit, certainly when there is no non-compliance found. So I would ask the subgroup to consider that as well, because this whole audit process should not be punitive to a lawyer that is doing what he or she should be doing with respect to compliance. Those are my comments. Thank you.
All right.
Okay, I think that's a great point. I look forward to the group giving the board formal feedback.
All right, I don't see any other hands with questions. Justin, is there any other direction that we need to give staff regarding this?
I don't think so. I have my direction.
Oh, I just saw.
Yeah.
Yep, saw another hand. Ms. King.
Thank you. I just wanted to add to that, as far as with real estate brokerages, one advantage for smaller brokerages, they never touch the money. It automatically goes to escrow. And that is an advantage. The larger companies still have a few agents that use the hold the deposits, but it's a very rare situation. And as a result of the oversight, it was much easier for real estate agents just to simply have their clients mail it to escrow, so it's hands off. It's been very effective. I don't know if the state bar could create a type of escrow as an option for some of the smaller companies, because no matter how much education and prevention you could do, there are so many people who are just not savvy with accounting. So I guess my question lies on, is the state bar open to create an escrow?
Yeah, it's a great question. So we did look at this. We learned that in the UK, particularly in England and in France, there is really widespread use of third-party managed escrow accounts. In fact, in France, it is mandatory and there are no attorney managed trust accounts. Every local bar has a bank associated escrow company or escrow bank. So I think that certainly is an option. I think there are many folks for whom that's quite attractive. It does seem like a very tremendous, significant change to our current structure. And so I think while it was interesting to the committee, the thought was that would be a quite aggressive approach sort of out the gate as we first begin our foray into this space. 5 years from now, 10 years from now, we may see that. But certainly we did look at those models. And as I said, there are other parts of the world where they're in place and have been in place for a long time.
All right. Thank you, everyone, for your thoughts and comments on this important work. Certainly at the board level, we're excited to be working on this. I know our trustees and staff have put in a lot of long hours on this potential proactive approach to some issues. So I don't think there's anything else on the agenda that we need to handle today. Justin, one last check. All right. And then when can we anticipate setting another full commission meeting?
You will get something for the first week in March. And you will get other doodle polls. There's a couple working groups that need to meet in the interim, but I will send them out, if not today, tomorrow morning, first thing. So there will be lots of polls.
All right. Make sure your spam filters don't get rid of anything saying doodle. So, all right. Unless anybody has anything else for the good of this body, I will adjourn till next meeting. So thank you to everyone who volunteers their time, and just thank you for your attention today. So
you do have one attendee. I don't know if you see that, Brandon. I don't know if you're interested in taking one last public comment. But
sure. Yeah, we took public comment at the beginning, but we can take public comment here at the end. So and I can't tell who it is. So please identify.
I believe it's the same person who gave it at the beginning. So I've unmuted. If you unmute yourself, you should be able to speak again.
Yes. Can you guys hear me?
Yes.
Yes.
Sorry, I'm in the car driving now, the hands-free. So I have some thoughts on the Girardi matter, if you guys are interested in hearing that. I was one of the last clients that firm dealt with before they were shut down and had firsthand experience with them.
Do we lose you?
Hello, no,
Okay.
I was asking if you guys wanted to hear some of my insights and input about the Girardi matter, but
yes, please.
so as far as the trust account issue goes, I was wondering if there was a way to also put in for attorneys to report other attorneys when they become aware of misconduct. Because I know Jay Edelson in one of the hearings had brought up that in Illinois that there is it's mandated for attorneys in Chicago to report attorney misconduct when they become aware of it. And Tom was not the only one there. I didn't deal with him directly until the very end, and there are a lot of people that helped him do what he was doing and looked the other way. And I know California, we don't have that law where we require attorneys to report each other, right? So would that be a way to help like mitigate the responsibility of the bar to handle all the complaints on their own, to put more of the responsibility on other practicing attorneys and hold more people accountable.
So, ma'am, we appreciate your comment on that, and we can't comment specifically on specific cases. One of the rules that we have as far as our meetings is a matter has to be agendized in order to discuss it as the body, and I think that staff has taken this comment down in regards to adding potential topics to future agendas. So we appreciate your interest in the work of this committee, and I would just ask that you, follow the ad hoc meeting agenda and look for future topics that are noticed in the future.
Yeah, and yeah, I have a question really quick too for Leah. Leah, is it too late for me to participate in the committee that you did all the presentation over?
Yeah, that committee is no longer active. It had kind of a short duration, but it's not too late for you to make public comments. So I'm going to suggest, I don't know if there's an easy way for you to contact me. My email is on our website, and I can make sure you get connected so that you're noticed of all meetings where these issues are raised.
Yeah, I really appreciate that. Thank you.
Absolutely.
All right, thank you for your public comment. All right, we will see everyone next meeting. Thank you so much for your participation. Have a good rest of your evening.
Bye.